Appeals Court, now sitting at Boston within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. My name is Amy Blake. I am joined today by Justice Eric Neyman and Justice Marguerite Grant. We are your panel for the 6 cases that are on our list this morning. Most of you have been here before, but a very quick reminder, each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read everything, so you should get right to your arguments. With that, I will call our first case, Commonwealth versus Amanda Bashford, docket number 24P121. Mr. McIsaac, good morning.
Good morning, Your Honors. And good morning, Your Honors. May it please the Court, Alexander McIsaac for Ms. Bashford. To get right to the point, we're asking the Court to vacate Ms. Bashford's conviction of possession of a Class A substance for 2 reasons. One being that the trial court incorrectly denied their motion for required finding not guilty, that the evidence presented did not meet the Lattimore standard of possession of a Class A substance. And 2, that the trial court improperly allowed inadmissible hearsay to be admitted and testified by multiple witnesses, specifically that the actual vial found was labeled morphine 4 milligrams. Going to the first argument that the required finding not guilty motion should have been allowed, I would say the strongest argument is that the Commonwealth did not show beyond a reasonable doubt, even to any reasonable juror or rational juror, that the substance in question in this case was actually morphine, the substance that was purported to be in the possession.
What do you say to the cases your sister cites where someone is stopped for drunk driving and the police see empty cans in their car that are labeled Budweiser, and the substance remains of the substance inside isn't tested? Can the jury infer that that used to contain beer?
So I would say 2 points. Yes, I think they are allowed to infer that, but in those cases, that's not the issue at hand. That is not the element that the Commonwealth has to show beyond a reasonable doubt. In the possession of Class A substance cases, you have to one of the elements that needs to be proven is that the substance in question is morphine. In the OUI context,
does it have to be shown by testing of the substance?
No, Your Honor. There are cases that say that the substance can be proved by circumstantial evidence, whether it starts with the Dawson case from, I believe, in the 1980s, all the way up to the Greco case I know the Commonwealth cites as well. There are cases where circumstantial evidence is enough. However, in this case with Ms. Bashford, there was not enough circumstantial evidence because, similar to the Nelson case that I cite, which was a different standard because it was harmless beyond a reasonable doubt based on the violation of Melendez-Diaz, they talked about in that case, though, that the circumstantial evidence of just white pills found in a prescription bottle with a label for the defendant for saying that specific thing was trazodone was not enough for it to be found harmless beyond a reasonable doubt that the drug certificates were submitted without admitted.
That's a sufficiency. We're talking about admissibility. What if the white pills were found in a bottle labeled aspirin, and the white pills matched the description of oxycodone in the physician's desk reference? Would the label aspirin on the outside of the bottle be admissible?
My argument would be no. And I know the cases cited talk about that it is especially the older cases talk about it's a reliability, but I think more importantly, a lot of the cases cited where they say the label is admissible, they have somebody who can testify to it, as such as a pharmacist or someone else, to say that it is inappropriate to come into either a hearsay exception. I still would argue that even though cases say that a label is admissible, I don't believe it's because it's not being proven for the truth of the matter asserted that it's not hearsay, as the Commonwealth says.
What if it was this? What if hypothetically the vial that came into evidence was the same vial that was found in the purse? This was a substitute vial, as I understand it. If it was the same vial, could the nursing supervisor testify that's what I found in the purse?
I would say, I think it would be a very different question. And I think the nursing supervisor or even the head of the pharmacy could say that's what was found, or the supervisor, the second witness, could say that was what was found. And I think I would still argue that that label itself would be hearsay and that possibly would have to be redacted. However, it would be a different question than what we had here. Here we have nothing submitted to the jury. And again, I think it would depend on how the testimony came out and the argument was made as to whether there was actually an exception to it. Because the Commonwealth, I believe, is arguing that, and I know it says in their brief, that labels in general are just not hearsay. They always are allowed in. And my argument, to your honors, is that I don't believe that's what the case law supports.
It's not that broad, but aren't there cases that say a computer-generated label from a manufacturer is not a statement of a person and therefore is not hearsay?
I do believe there are cases that state that. And I think if the testimony had come out to actually corroborate that in this case, we might be a different story. I think
the alleged corroboration, we haven't made that decision yet, but the alleged corroboration here is the testimony that it said morphine 4 milligrams, and it came in a vial, and it was taken from this, I forget the name of it, but this dispensary, this Omnicell dispensary system. And here's a photo of what an Omnicell dispensary example of a morphine vial looks like. And you can see on the photo it says morphine. It appears to be a pharmaceutical or manufacturer's label of some sort. Why isn't that enough corroboration?
And I believe the reason why I say that's not corroboration in this matter is I would say that the testimony at trial was not specific enough that to talk about. Yes,
Was my summary I just gave
that was
fairly
correct.
accurate?
That was accurate, yes, Your Honor. And
Okay, so tell me why that's not enough.
Yes, I would say that's not enough because, again, we are talking about a photograph of a vial. That was not what was actually found. And yes, they testified that it was similar. And I think that's the key language here, why it's not enough. It's not saying, no one testified that's exactly the same, or I don't think specifically they said that the label was exactly the same. They didn't talk about the label itself. They were talking about the vial. And if I think there was testimony from either the head of the pharmacy or either of the witnesses that found the vial that said the label itself, and I know that wasn't the key part of the trial, which I can understand, but the testimony was the label was the exact same as the label that was found on the vial that was in the purse.
Does that go to hearsay or does that go really to authentication, what you're arguing right now?
I would argue it goes to hearsay. I think it would go to authentication as well, but more hearsay to your question of if it had been enough corroboration to say that this was a label that was done in a normal course of business, as you stated, it was a machine printed out label, that a judge could make a specific finding to say that this is not hearsay for that reason. I would argue in this case, though, where we don't have the actual violent evidence to corroborate it, we just have a photograph. It was a color photograph, but one that everyone testified looked similar. I don't think
So
it was
is it
enough
the
to say.
admission of the photograph of the facsimile vial that's the problem? Or is it the nurse's testimony about what the original vial said?
It's the testimony, or my argument is it's the testimony of what is brought in.
But if the original vial was in evidence, the nurse could read it, or even not
Yeah.
read it and just let the jury read it.
And I think that would be a very different question. I think that the jury would most likely be able to read that. I think you could make an argument that even the label on the vial was hearsay. But again, I think it's a different question because then you also can allow the jury to look at and to see if it is a computer-generated label and would actually, as a trial judge would find, it's not hearsay or not.
How does your argument change, if at all, with the testimony that, and I think it was uncontroverted, that your client withdrew 4 milligrams of morphine from this exact machine in this exact way the night before this vial was discovered?
I think it doesn't change my argument or the testimony about the label, but also even to the sufficiency of the evidence. Because just because you have testimony that someone, again, withdrew a vial from this Omnicell dispensary, used it the day before, does not show that the vial that was found in question, and if we're still talking about the hearsay label, does not show, again, that the label itself is the same as all the labels in this Omnicell dispensary.
Was there an objection to the photograph of the supplemental vial?
There was not, Your Honor. So there was no objection to the photograph itself coming into evidence. The objection at trial was to the testimony about both, that it was a vial of morphine that was sustained, and then that the label itself was hearsay. That it was just overruled by the trial judge. There was no objection to the photograph. There was unobjected to.
Does it matter that a medical professional who's administering morphine is going to rely on this label when they inject it into a patient and they're not going to retest it to make sure it really is morphine?
I don't believe it is in this matter, because, and this is why I say that, Your Honor. If it had been found unopened and it had been come from the dispensary itself. And I think that's what the photograph showed. It was an unopened vial that had not been broken. I think that is a very stronger circumstantial case, and I think what Your Honor is saying, I don't think someone would have to retest it to say an unopened vial that's been labeled by the manufacturer for morphine that contains morphine. What we had here, and the testimony came out, was that it was a 4 milligrams or 4 milliliter vial. Half of it was missing. Testimony did come out through the head of the pharmacy that what we were talking about was a very small, close to a teaspoon or less than a teaspoon amount of liquid. And that was a clear liquid found in an open, cracked open vial. And that vial had been opened and used.
Submitted in conjunction with other evidence that the nurse had ostensibly given morphine to patients earlier, either that day or the prior day and the day before that as well, correct?
Correct. There was evidence submitted that she had given, I
So
believe.
that would be some corroboration as well.
It would be some corroboration, but again, I don't believe that you could say that the amount of time from when she allegedly gave this morphine in, similar to vials, is enough to say there's enough circumstantial evidence to say that this substance contained in this vial, which is opened, had a clear substance, is morphine in this case. And I would specifically...
So who's the declarant of the hearsay in your argument?
The declarant would be, I would say, the alleged person or system, I guess, that made the label. But again, I don't believe...
It's not a statement of a person, though.
I would argue...
If it was handwritten,
Correct.
probably. But if it's a printed label, as was testified to, that was like the vials we supply at the hospital through Omnicell, which is our electronic medication dispensing machine. How can that be a statement of a person?
I would rest that it would be still a statement, Your Honor, but I can understand, again, I think if there had been more...
Not a statement of a person. That's what Mass Guide to Evidence 801A tells us, and that's what I think it's the Commonwealth versus Thistle 457 Mass at 197 tells us.
Right. I think that if there had been more testimony about it that said that the label itself was the one that was printed by the manufacturer through the Omnicell system, I think that would have been a clear question that it would not be a statement by a person. I believe in this case there was not enough testimony to corroborate that part and to have the trial judge be able to overrule that objection. And just to briefly go back to the Lattimore standard, the required find not guilty, I would cite that there are cases such as Nelson and others that talk about that, especially Payne, which I cite in my case, that the appearance of the substance itself, even with a label, in the Nelson case it was that there was a prescription label that was admitted to evidence and white pills were found. They said that is not enough. And they cited the Greco case that said circumstantial evidence is enough. But Greco had specifically, and they listed out, and in addition to the prescription label for the bottle with the defendant's name on it, the defendant was in front of that pharmacy standing in front of it. They had the pills that were given to another individual. And then when he was questioned, the defendant stated specifically that they gave me $10 for those pills. There was an admission tied to it as well as other circumstantial evidence. Here, the only testimony that was allowed by the trial court was that there was a label, similar to a prescription label, on this open vial, and that there was a clear liquid inside of it.
What if Janet Ray had opened the purse and in the purse had found items belonging to your client and had also found Janet Ray's own credit card, her American Express card, labeled with Janet Ray's name? Could Janet Ray read her own name, or would that be hearsay?
I think she would be able to read her own name, because again, I think that would be a statement not being brought in for the truth of the matter asserted. I don't think they would be going in to show or prove that it was for the truth of the matter asserted. The issue here is that it was being used specifically to show that what was in the vial was morphine. And that's my issue, or my client's issue.
But wouldn't it be being used to show that the credit card was stolen property?
If that was the issue at hand, you could argue that. I see where you're going with the honor. If it was to show that it was owned by someone else, again, I think on a credit card it's also a different testimony. I think it's be clear that this was on a credit card is a manufacturer or credit card company creates this. This is not a statement of a person. Different, again, to the testimony we had in this trial about the vial. And I also think it would depend on whether the credit card itself was admitted. But I think a juror is in a more reasonable position to say, we know what a credit card is. We know that they are print on or embossed writing on that would come from a manufacturer, versus a medical vial, which I believe we need the testimony to be able to corroborate that is actually not a statement by a person, which I don't think we had in this case. And I would argue that that's why it's impermissible hearsay. And just to briefly go towards, I think the other two elements of the Lattimore standard are as to possession of a Class A substance. While they're not the stronger arguments in the matter, I do believe that it was a weak circumstantial argument, and I would say not enough for any rational trier or juror to find that Ms. Bashford actually constructively possessed the items, even though she did admit that it was her bag. I don't believe that there was enough to corroborate that. And lastly, and more importantly, that they had to show she actually knowingly or intentionally possessed those items. She denied knowing it. The only evidence that even tied it to Ms. Bashford, what I think may get you over the Lattimore standard as to the constructive possession, is that the bag was hers. I don't believe there's any other corroboration to show that she had knowledge of the medicine that was in that bag, especially since the reports that were talked about specifically showed that she had dispensed all 4 milligrams of the morphine both times that she had given it from the prior times. So there's nothing to corroborate, such as a waste audit report or anything else, to show that there was leftover morphine, to tie those 2 vials into where Ms. Bashford actually owned it in her bag, or alleged bag. So respectfully, I would ask your honors to vacate the conviction for possession of Class A substance for those 2 reasons. And unless there's any other questions from the panel, I would rest on my brief.
Perfect timing.
Thank you
Thank
very
you,
much, Your Honors.
counsel. Attorney Semmel.
Good morning. May it please the court. I'm Catherine Semmel on behalf of the Commonwealth. I think that Massachusetts case law is replete with examples of cases where the courts have permitted testimony about labels or labels to come into evidence.
What's your best case? Because it looks like you cited a Rule 23 or 128, but what's your strongest published case for that proposition?
I think that Clark is probably my strongest published case, even though it's an SJC case, first of all. They specifically reference hearsay in it. A lot of the cases don't specifically reference hearsay in their description. They just say that it's competent evidence, even sometimes when hearsay was raised in the briefs. So I think Clark, even though it's the imprint on the gun and not, a label.
Well, let me ask you about that, because as I understand Clark, that was with respect to the caliber of the gun, and caliber is not necessarily an element, whereas here, Class A morphine would be an element. So does that distinguish Clark?
It is not clear to me from the facts of the case. I assume that the caliber of the gun was important for some reason. I don't think it's discussed in the facts, but I assume that it has some connection to the case, and so it was, that it wasn't being introduced for no reason. The other cases I would cite the court to that are not unpublished, although the unpublished cases I think are probably most on point for a couple of reasons, but Greco and Alicia are cases where somewhat different analysis. They were cases where a certificate of analysis was incorrectly introduced, and they looked at the rest of the evidence to see whether or not it was harmless beyond a reasonable doubt. And those cases both involved cases where there were labels or references to labeled prescription bottles. So I think those are helpful. The case that is one of the other cases that is helpful is, I think, Driscoll, which is an unpublished case. That's the only case that really talked about the business records exception and really analyzed it from that aspect, which I think is also applicable here. I don't think the courts have been particularly clear about the reasons why it's admissible. But I think we can deduce whether it's because it's not a statement at all, as Justice Neyman pointed out, or because it's a hearsay exception under the business records. The courts have held for decades and decades that manufacturer labels are admissible as evidence of the contents of what they're labeling.
How does label plus clear liquid constitute proof beyond a reasonable doubt, even under Lattimore?
I think that there was significant other evidence in this case besides the specific vial that the person saw. There were 3 witnesses who saw that. Each of them had been longtime employees of Anna Jake's hospital. Each of them confirmed that the vial was consistent with the morphine that was dispensed by their Omnicell system. In addition, we have the photo, which, as the court already questioned, was introduced without objection, which showed a representative vial, which they also said was consistent right before.
So let me ask you a hypothetical. Suppose I'm getting on a plane tomorrow, and I take out of our medicine cabinet an empty vial. It's labeled OxyContin, for which you need a prescription. It's illegal to possess it without a prescription, right?
Yeah.
And assume further that OxyContin comes in it's a generic version that comes in a plain white pill. And I put Tylenol in a plain white pill into that vial or that medicine holder, and I'm stopped at the airport, and they see OxyContin, and they charge me with that, but they throw away the pill bottle, so it's never been tested. I can be convicted for possession of whatever class substance OxyContin is based on those facts?
Well, I think that those facts are significantly less compelling than the facts in our case.
So
Is
answer
it
my
possible-
question first. Can I be convicted based on the facts I just recited to you? Because if I can, that's really troubling to me.
It is troubling, I agree. And I assume in that case that the defendant would introduce evidence that he in fact put something else in there. Is it sufficient? It may technically be sufficient. But I have to say that in cases...
Never been tested, it's consistent with other substances. How can that be proof beyond a reasonable doubt? I'm really struggling with that.
Right. Well, I think if you do look at cases, for instance, if you look at a case that the defendant relies on, Nelson, which is distinguished from the Alicia and Greco cases, the court did hold that where there was slim evidence like that, just a label and whatever, that it did render the certificate of analysis that was improperly introduced not harmless beyond a reasonable doubt. So that is some indication perhaps that you couldn't be convicted. Obviously, that's not a sufficiency case, so it's slightly different. But yeah, I think usually that there is additional circumstantial evidence besides that in order to uphold sufficiency. But as to where to draw the line, I'm not completely sure, obviously, how it would play out. So with regard to assuming that it was improperly introduced, our prejudicial error argument, and sufficiency arguments are largely the same, and they're the elements that I laid out, the other evidence that supported the testimony concerning the vial. And I will note from a prejudice standpoint that the judge was careful in what he allowed in. So for instance, while he did allow witnesses to testify that the label read morphine, he sustained...
Didn't let them testify what it actually was.
Yes, exactly. And in addition to that, we have the additional, evidence of the Exhibit 2 photograph and the Omnicell records, and that...
If it was a handwritten label, would it have come in?
That's a really good question, Justice Grant. I think it would be... I picture when I was thinking about this scenario, I was picturing like, a bottle of moonshine or something in somebody's cabinet. But if it's a handwritten label, I think it would depend on the circumstances about what testimony there was about how that label was created and who did it. In this case, there was some testimony, which I didn't reference directly, from the pharmacy director about the fact that they do rely on these labels to tell them what is in the vials, that the manufacturer puts them on.
What if it was a different brand than what this particular hospital used?
Well, then I think we would lose all the connecting factors, and then we would be closer to Justice Neyman's hypothetical of just a random vial that said something. And whether that's sufficient or not, would be a close call, certainly. If there are no further questions, I would rely on my brief.
I don't see any. Thank you very much, counsel. Excellent briefs, excellent arguments. The case is under advisement. Thank you both. Our next case is Commonwealth versus GYAN SHARMA. I'm sorry if I've mispronounced that. Docket number 24P417. Good morning, Attorney Contatese. How are you?
Please support Adriana Contatese for Mr. Sharma, who contends he is entitled to a new, fair trial, and I am aware and grateful that the court is familiar with the record, but I set my argument up to just do a very quickie setting the scene of the sleeping incident.
Sure.
Thank you. So the first day, this juror was selected right off the bat. He was juror number 3. He was told to come back the next day at 11 o'clock, and he did come back the next day at 11 o'clock, and the second day, evidence starts at 12:35. There were opening arguments and 12:35 opening arguments and then evidence. So there were 15 pages of the victim giving her direct testimony. At that point, the lunch recess was called. During the lunch recess, there was a sidebar, a voir dire of the first complaint witness, and everybody went to lunch, and then at 2:05, evidence continued, and the victim's direct testimony continued for another 29 pages, and then the victim was cross-examined for 35 pages. At the completion of the victim's testimony, everybody went to the sidebar for just a quickie sidebar to get ready for the first complaint witness. And it was during that sidebar that the prosecutor told the judge, and the judge agreed, that juror 3 had been sleeping, and that...
Well, I don't know if that's quite what the language was. Wasn't it more like nodded off?
Napping. I have the whole, I think I reproduced it in my brief, but I have the page too. The prosecutor says, maybe one of the jurors might have dozed off. The court says, I did see that, yeah, someone else gave him a little nudge. And then the court says, right, I don't think he was indiscernible, napping very long, but he did close his eyes. So the
I have
court
a couple
said,
questions for you.
Yes.
How do we know that this juror is the same juror from the jury selection that you refer to as juror 3? Is it just the circumstantial evidence about the fact that the judge mentioned this juror had issues with work?
No, this was juror 103 in the questionnaire, and he became the juror who was seated in seat number 3.
So do we have something in the record that says that?
I do have something that I want to talk about, but I was going to wait till the end of this because it's important.
Okay, let's assume for the sake of argument that this is the same juror that you're
Yes, thank
talking
you.
about.
Okay.
How do we know at what point in the testimony the juror nodded off and for how long it was?
Well, that's the problem. We don't know. And I have a few things to say about that I think is really important, because the way that this happened, we have this hour that we know it could have happened during that hour.
So should we assume it was for the whole hour?
Well,
Well, the judge said, but not very long, so we have to credit that. There's nothing that
but what part of...
contradicts that. Now, the question, that begs the question, what does that mean?
Well, that's true. We don't know. We have no idea. And not only that, but this was the most significant portion of the trial. There was no other portion of the trial that was more significant. And the worst part is...
What was the most significant portion? You have a whole hour, and there's a not very long interval during that time. When is that?
Well, the first part of the victim's testimony before they went to lunch is when the victim said all the bad stuff. The second part, during this time when the juror was caught sleeping, was when all the good impeachment happened. This was a credibility case, and all the good impeachment happened there. Even during her direct testimony, her reliability, her memory, and her credibility was called into question.
Could all this have been flushed out on a motion for new trial?
No, this wasn't flushed out for...
I said, could all of this have been or be fleshed out in a motion for new trial, where defense
No.
counsel would make a proffer and the judge could respond and counsel could testify and the judge could make findings on the record and say, I don't know how long the juror was out and that troubles me, or I said but not for a long time and that was, no more than 10 seconds, etc. I mean,
No, it's not appropriate at all for a motion for a new trial.
Why?
Because the trial judge was in charge of making sure that the defendant was getting a fair trial. This was the trial judge not only
motion
did the,
and the trial judge would presumably be the motion judge on a motion for new trial who could
why should the
elaborate.
defendant give the trial judge another opportunity to put things on the record when the judge, first of all, knew the kid had to work that night?
Because
So
the
she
judge
said-
has an obligation to ensure justice and not to protect the record.
So, well, why didn't the judge put it on the record at that time? It wasn't
How do
like this
we
was a
know-
surprise.
How do we know that defense counsel wasn't making a strategic decision to refrain from objecting because this juror was the only person of Asian descent on the jury and your client was of Asian descent?
Well, this is what I have to say about that. That is the most ridiculous thing I've ever heard, to engineer diversity on a jury, specifically because I think that the juror was Chinese and my client is Nepalese, and I think that China invaded Nepal, and so they're enemies. So I don't really understand what the purpose of that was.
So what do we take from the lack of trial counsel making any objection or asking for any further inquiry? You didn't bring an ineffective assistance claim, so I take from that you don't think he did anything wrong. So what do we take from his lack of objection?
No, I don't think he did anything wrong, because even if he had objected, first of all, we know that
But he didn't object. If he had objected, we'd have a record.
But what's the purpose of an objection? To bring the problem to the court's attention. The DA brought the problem to the court's attention.
Right?
Pardon me?
To preserve any error.
The error was preserved. It's right there on the record. The court had the opportunity to inquire. She saw this guy asleep. The DA saw the guy asleep. This was a reliable report of a sleeping witness. Now, another thing I thought about is, when jurors are in a trial, how are they sitting? What do they do? Can anybody ever think of a time when jurors in a trial were looking at each other? They never look at each other. They look at the bench, they look at the witness.
That's not in the record. This is pure speculation.
Well, it is in the record that the judge saw the juror nudge
Right, but
the
everything
other.
you've just described, let's stay with what we have on this record. And we're limited in this record in part because we don't have an objection and a discussion on the record. We don't have a motion for new trial. And I might agree with you that it would have been better practice for this judge to have had a voir dire, but doesn't Villalobos tell us that that's not required? And we're reviewing for an abuse of discretion, are we not?
No, Villalobos does not tell us that. Villalobos tells us that a sleeping juror is always structural error, and that when there is a reliable report of a sleeping juror, the judge must take some action. Not only that, but the judge also knew that the juror had to work the night before, and I think at one point she says that he's exhausted. So didn't
May I
this
interrupt
also...
you? Sorry, because you just raised Villalobos. It's an important case. And Villalobos says at footnote 1 as follows: "This is not to say that a voir dire is always necessary. There may be circumstances where a judge received reliable information that a juror is sleeping and properly exercises his or her discretion to intervene without conducting a voir dire." So what circumstances was the SJC contemplating?
Well, I don't think that the SJC was contemplating a circumstance where the judge actually saw. I can't think of one reason why the SJC would say, yes, the judge saw him sleeping, they saw a juror nudge him, but the judge did nothing. How can we know what this juror missed? And secondly, how can we know that this juror was just not simply too exhausted to give this the attention that it required? And furthermore, how do we know that other jurors were not distracted by his sleeping?
Because they were all looking straight ahead.
Well, I mean, think about it. When do jurors never look at each other? If for a juror
If
to
You still
judge-
haven't answered my question, which is, in footnote 1, the court actually said the judge received reliable information. So it's reliable.
Yes.
Judge the judge here, yes, a juror was shutting their eyes, napping, whatever it may be.
Yes.
And the court said the judge may still properly exercise his or her discretion to intervene without conducting a voir dire. What type of circumstances was the SJC contemplating? I'm going to ask your brother the same question, but I'm just curious. I don't know the answer to that. That's why I'm asking it.
I don't know, but I suppose the judge would have had to have put something on the record. I just saw him close his eyes. He didn't, I will keep an eye on him. I am going to, what do you two lawyers think about it? I don't know. That's the problem.
Well, the judge said, I saw the juror, had his eyes closed, not for that long, and he got elbowed by the juror next to him. But again, it wasn't for that long. That's what she found on the record. So why is that insufficient here?
Because a judge is taking notes. A judge has to take case notes. This is the most important part of the trial, so she was taking case notes. The question is, well, how do we know? We don't know. We can never know, and that's the problem with not putting this on the record.
Not for long. What do we take from that, other than it was not for long?
Well, that's a good question. I mean, was it half of that hour? Was it 15 minutes of the hour?
That would be a long time.
Was it the 2 minutes where the victim says, 5, 6, 7, 8, something like that? There's a huge difference between being a 5-year-old victim and an 8-year-old victim. Was it the 2 seconds when the victim had to answer the question from defense counsel about, well, why did you never mention that the penis was touched before? I mean, that's pretty significant. This was a credibility case.
If the defense attorney had asked, or the judge had done it sua sponte, would it have been appropriate to designate this juror as an alternate?
That's probably what I would have done if I was a judge, and I see that before. And I don't know if that would really be I think that might be some kind of judicial interference, but if it's going to be judicial interference, it's certainly set up to be much more fair than to engineer a juror who's exhausted.
If the judge had done that, though.
Pardon me?
If the judge had done that, though, wouldn't it be likely or possible that an appellate attorney would be arguing now that the defendant was deprived of a person of color on the jury?
Well, like I said, I really don't think so, because if you wanted to look behind that issue, as I said, I mean, Nepal it's a huge enemy of China. So if you want to really nitpick on diversity, I suppose that's the appropriate thing. But no, I wouldn't have chosen that. I wouldn't. And actually, I've had cases before where, there was a problem with the juror, but you know what? That juror wound up being an alternate, so I'm not going to really worry about that. I want to just go through my list. So going to the Commonwealth's brief, the Commonwealth says in their issues statement, the Commonwealth says, the voir dire of a juror who had closed his eyes and may have briefly napped before being promptly alerted by another juror. That is totally speculation. I mean, that complete and total speculation. There is nothing in the record that supports that. There's nothing in the record that doesn't support that. I don't blame the Commonwealth, but of course the Commonwealth was the party who had complained about this not once but 2 times during the trial.
I don't think they were complaining. I think they were doing their job and alerting the judge.
I agree. And that is why I don't think it's relevant that the defense counsel did not object, because the purpose of an objection was already fulfilled. There was a functional equivalent of an objection because it had been brought to the court's attention and the court could have taken care of it.
Isn't the purpose of an objection also to say, Judge, there's a problem here and my client's not getting a fair trial because that person's asleep?
Well, yes, but
that's the difference. Without an objection, we're left to presume that defense counsel was fine and the status quo was okay. That's why, and you know this better than I do, that's why you launch an objection, to explain what the unfairness is then and there.
it was the trial court, the bottom line is it was the trial court's job to take care of this. It would have been easy to put this on the record. They were doing a sidebar at the end of that. The court could have taken half that time to put it on the record. But as I said, there are super important parts of that hour that were just seconds of impeachment that really could have made a huge difference in the trial.
And we're going to have to leave it there, counsel. Thank you.
I do have an important issue about the record. I guess I can send in a letter.
So we're going to have to leave it there. Thank you.
Thank you.
Attorney Blatchford?
May it please the Court, Howard Blatchford, Assistant District Attorney for Middlesex on behalf of the Commonwealth. In this case, the Court properly exercised its discretion when the judge decided to proceed with the trial without holding a voir dire of this juror.
Would you agree with me that, I'm not asking you to concede error, but it would have been better practice for her to have done a voir dire, yes?
We might not be here today had that been done, but the judge acted within her discretion. As the Court's already noted, the SJC has recognized that a trial judge has broad discretion as to what to do in these circumstances, and
so
that a voir dire is...
how do you pull apart? Attorney Conchitese says there's about an hour at issue based on the timing of the record. We have the judge's statement and the prosecutor's statement that the juror may have dozed off for a little bit. The judge says, I don't think he was napping very long. What does that mean in the context of an hour? How do we know?
We don't know.
What can we infer from it?
What we can infer, I believe, is that no objection was raised by the judge or by defense counsel or by the Commonwealth at any point in time.
But why didn't the judge just say to defense counsel, Mr. Glynn, what do you want me to do?
Well, during the colloquy, he said the word "yeah" a couple times. So I infer from that he agreed with the judge's description of what had happened and that this juror was perhaps napping and that he was promptly nudged by someone, given an elbow, when that was apparent. So I would also point out, if you look in the transcript, that, when they had this sidebar, this wasn't the issue that they brought up first at the sidebar. The Commonwealth went up there to discuss the procedures for handling the first complaint witness. And it was only after they got well into that, on page 224 of the transcript, down towards the bottom, was this issue raised about the sleeping juror. So we don't know whether the juror was nodding off then, when they got up to do the sidebar, or whether it was earlier. We don't know. We don't know how for long it was. What we do know is what the judge recited on the record.
I'm sorry, go ahead.
We have many cases, this court and the SJC, on sleeping jurors that sort of run the spectrum. And you've cited Ralph and McGee. Where does this case fall?
I feel that it falls very close to Ralph R. I mean, we have really two sets of cases, or maybe a set of cases and then an outlier of a case. But McGee, Brown, and Villalobos all involve situations where a juror was observed or reported as, in one case in McGee, snoring through the AM session so loud that some jurors weren't able to hear, then snoring again through the PM session before finally being awakened with a nodding head. Brown, where they were sleeping through all or part of the testimony of two witnesses. And Villalobos, where a juror was observed sleeping several times during one day of testimony, and then another juror was sleeping
So is it the length of the sleeping or the subject matter during the sleeping?
Well, I'd say they're both relevant, but these extreme cases where a voir dire has been deemed required involve situations where there was lengthy periods of time where the juror was observed inattentive. In Ralph R., we had a situation where the juror's head was down and his eyes were closed, And when the judge asked the jury to look up at the monitor because a video was going to be shown or a picture was going to be projected, he immediately snapped to attention. So I think that is analogous to the neighboring juror giving the juror in this case the elbow, and he came to attention again.
Can you answer my question about footnote 1 of Villalobos? Do you need me to repeat the question?
Yes, I do.
Villalobos at note 1 says, "This is not to say that a voir dire is always necessary. There may be circumstances where a judge received reliable information that a juror is sleeping and properly exercises his or her discretion to intervene without conducting a voir dire." And my question is, what circumstances do you think the SJC is contemplating there?
I can't say for sure, but
No one can say for sure, but that's why I'm asking the question.
I would think it would be a circumstance similar to this, where the judge actually made an observation of what happened. This didn't come on a report from just counsel or someone else. It came by it came on the assistant DA brought it to the attention of the court, but the judge said, yes, I saw him napping. It was just for a moment, and then he got the elbow and he came to. And in this circumstance, it was brought to the judge's attention. The judge had a discussion with counsel concerning that. Defense counsel agreed during this colloquy with what was being said. He said, yeah, twice, never asked for a voir dire.
Because a sleeping juror can be or is a structural error issue, can that be waived?
I believe that there is case law dealing with...
Can there be a strategic choice that, for lack of a better term, trumps the structural error or the alleged structural error?
My understanding is that if no objection is made, then structural error, to the extent it exists, would be, or the question of structural error would be reviewed for substantial risk or miscarriage of justice.
So let's say, for example, defense counsel had said here, you know, I saw that juror, he was asleep for about 3 to 5 minutes, but Judge, I'm making a strategic choice here. I want that juror on here. My client wants this juror on here. We're all set. Do not strike this juror. And the judge followed that request.
Well, I think
isn't there still structural error, or can it be waived?
It can be waived.
Okay. I know you weren't expecting that, but do you have a case for that proposition?
I don't off the top of my head. I can't recite the case off the top of my head. I could supply that to the court. In any case, the facts that we have in the record here do not suggest that there was a serious possibility of a juror sleeping for a significant portion of the trial, and that appears to be the test for...
Does it make a difference that this issue arose while defense counsel was conducting the examination, when presumably he may not have the opportunity to look at the jury as much as, say, the prosecutor or the judge would?
From the judge's perspective, I would think not. That the judge's duty is to ensure that a fair trial is had, and it wouldn't matter where it occurred. So I don't see that as being the issue. The defense attorney in this case clearly had some awareness of what had happened, because he acknowledges that during the colloquy by his use of the word "yeah" twice. So
Let me ask you, at page 17 of your brief, you discussed Dancy and what could have been developed at a motion for new trial, and obviously we don't have one here, but beyond the statements from the prosecutor and the judge that we have on this record, what else would a motion for new trial potentially tell us?
Well, I have to speculate on that. I can't say
I guess
for sure.
that's the question, though. You make the point that perhaps the defendant should have filed a motion for new trial, and Dancy is a case that there was no abuse of discretion, and there's some discussion about a sleeping juror and the potential to develop more of a record for a motion for new trial. So is it your view that we have enough or don't have enough to decide this on?
I think we have enough to decide this case on this record. But to go back to your original question, just to answer it, I would say that if there had been a motion for a new trial, an evidentiary hearing, the judge could have clarified on the record exactly what it was that she observed, how long, when it occurred, and how long it for how long it lasted, and any other witnesses, I suppose.
And in fairness, that could have helped or hurt the defendant's argument, right?
We don't know.
So strategically, might have rolled the dice and said, I don't want any more on the record on this issue.
Possibly. If there are no further questions, the Commonwealth will rest on its brief.
I don't see any other questions. Thank you both very much. The case is under advisement. I'm going to call the next case, but for the lawyers and parties in the room, after this third criminal case, we're going to take a brief 10-minute morning recess, and then we'll return to hear the civil list. So the next case is Commonwealth versus WILFRIDO Castillo, 23P841. Good morning.
Hi. Good morning, Your Honors. May it please the Court, Zachary Lown for WILFRIDO Castillo. Your Honors, in this case, there was insufficient evidence that Mr. Castillo knew or believed SD was under 14, as required by Commonwealth v. Disler and Commonwealth v. Philopoulos.
Can I just ask you, I know they're all interrelated. If we hypothetically agreed with you that there was a problem with the jury instructions, we don't have to reach anything else. Is that right?
I don't know the answer to that. I think that the sufficiency, I think that if he was put at bar and placed in jeopardy and the Commonwealth failed to produce sufficient evidence to prove a necessary element, then I think it does implicate the need to reverse the verdict. That would be my instinct.
So the Commonwealth didn't meet its burden on the element, and the judge didn't properly instruct on what the Commonwealth's burden was as to that element.
I agree with both of those things, and I think that the errors are interrelated because.
Yes, that's what I'm trying to figure out.
I completely, if that's the implication, I agree that the errors are interrelated because the jury could not assess or hazard a guess as to Mr. Castillo's knowledge or belief, whether or not the jury was permitted to even do that. I think the case law cuts against it, but here they weren't instructed to do so. And so that would detract further from the sufficiency.
Before you get to the instructions, this dovetails with Justice Blake's question,
Yes.
which is it still, enticement requires the victim to be under 16 years of age, and in the context of indecent A and B as the under 14 as the target offense, it requires the person be under 14.
Yes.
Is there a lesser included here, for lack of a better term? Like, suppose the defendant attempted to entice someone under 16 to indecently assault and batter them, and there was proof and a proper instruction that the person need be under 16 but not under 14. Is there a lesser included offense there or not?
There is not a lesser included offense because, for lack of a better term, simple indecent assault and battery also includes an additional element which indecent assault and battery under 14 does not, which is lack of consent. So the two are separate offenses, and that would be my first.
So for purposes of the required finding, if we agree with you, it bars retrials, what you're saying?
Yes, yes. That would be my position.
It's not an easy question. It's not.
Yeah, that would be my position. I think I guess what I said before, instinct is that if he's placed at bar, there isn't sufficient evidence on an essential element, it has to be reversed.
Well, I have a question about the instructions.
Yes.
So, hang on one second. Your argument is that the instruction misstated the elements of the target offense because it didn't instruct, if I understand you correctly, that the defendant must have known or believed that the victim was under the age of 14. Is that correct?
Yes.
What case says exactly that? It seems to me that there's slightly different language used in the cases you cite. So could you help me out there?
I think that is Philopoulos. I think that Philopoulos, which extended, not necessarily extended, but maybe applied the rule enunciated in Distler that knowledge or belief of age is the necessary element of the offense, which the Commonwealth must prove beyond a reasonable doubt. And the SJC's rationale there involved both constitutionality and statutory construction. And the statutory construction piece of it looked at the way the word intent was used in the statute as it applied to the mens rea or the knowledge or belief requirement.
And it concluded it's a specific intent crime.
Yes, yes. And I do think that goes beyond the technical reading of the statute and implicates fairness as well, because greater condemnation, greater opprobrium, usually heavier penalties are assigned to individuals who violate statutes committed against someone below a particular age. So I think that in requiring that the Commonwealth prove beyond a reasonable doubt that the defendant knew or believed the alleged victim was below this particular age.
But again, where does that language knew or believed? What I'm looking at, and it may not make a difference, but I'm looking at Philopoulos right now, and the court there used different language. It did not use knew or believed. I think it used language to the effect of must prove the defendant intended to direct his sexual advances to an underage victim or something to that effect.
Yes, and that the Commonwealth must prove that the defendant knew that the intended target or the intended victim was below the age of 14. That was the import of Distler and how the SJC was able to uphold the statute in Distler by doing away with a situation where one could be conversing with an individual who they believe is over the age of whatever the requisite age may be, only to later find out that they are not and then be convicted of a crime. That was the potential hazard that the defendant raised as a constitutional challenge to the statute, which the SJC dealt with in Distler, and then required in all cases going forward, under both Distler and Philopoulos decided that same day that the Commonwealth must prove this knowledge or belief as an element of the offense.
So obviously, one of the things we don't have in the record is, for example, a photograph of the alleged victim in this case. And, you know, it's possible, right, that the jury could look at this young woman and make a determination that it was obvious to everyone that this was a person under the age of 14. Although in today's day and age, these 14-year-olds often look like they're 24. I recognize that. But how do we know that the jury couldn't make that assessment, that it was so obvious that, of course, by inference, the defendant knew she was under 14?
So I guess the two answers. One would be there was, to sort of reemphasize how you started, there was no evidence of that, of what she looked like.
But we have this weird thing in the closing about a petite 13-year-old, and I'm not quite sure what that means, but that caused me to think, could the jurors have looked at this young lady and it been blatantly obvious that she was under 14?
So I do cite a slew of cases, published cases, which hold that appearances alone is insufficient. To prove age, and this
have appearance along with his stepdaughter's age and friendship with this young lady, right? There's a little bit more than just appearance.
Yes, I think the
His
stepdaughter.
consciousness of guilt, him calling her a good girl in the text, which suggests he's speaking to a person of very youthful age.
Her mom saying she dropped her off for a play date.
I mean,
I don't deny that the texts were inappropriate. I wouldn't sit here and argue that. I argue that they did not show that he knew she was below the requisite age. So even if he believed she was younger, for example, his stepdaughter, I think in my brief I said she was 14 or 15.
Well, maybe he didn't know it, but as you say, he could have believed it. And under Lattimore, doesn't that, all of the circumstances that Justice Blake and I just delineated get you there under the Lattimore standard?
Sorry, does what get you there under the Lattimore standard?
The facts which we just recited, the facts that are in there, him calling her a good girl, dropping her off at a play date, the time she spent with the daughter, the
Petite appearance.
petite appearance. Although the petite appearance came in closing, I think, so that's post motion for required finding.
Yes, so I think that would suggest that she is of high school age, and
Plus the consciousness of guilt. I think under Lattimore, it suggests that he knew he was trying to commit a crime, arguably.
Not this specific crime, which required proof of knowledge that she was...
Or belief, as you said.
Proof or belief that she was under 14 specifically. So there is very few published cases under this enticement statute. I've read every one, and unpublished. An unpublished case that is on point here is McClellan, which I talk about, where the defendant committed a series of sexual assaults against a girl, culminating in a brutal aggravated rape, and the court ultimately vacated his enticement conviction, though he was convicted of other things, because though he picked her up from high school, that was insufficient proof, standing as it was, to show that he intended to entice
What
a
about
victim.
the fact that the trial is only 6.5 months after the date of the offense? Couldn't the jury look at the victim on the stand and and consider that?
I think that this is where, so now I think we're sort of in the sufficiency box, and I think this is where it also bleeds into the jury instructions, because even if the jury were permitted to hazard a guess based on physical appearance, though I think, as Justice Blake said earlier, age is rather indeterminate these days.
But don't jurors do that all the time in child porn cases?
Do what?
They look at images, and the person doesn't testify. Nobody knows who the child is depicted in the video or the image, and they have to make a determination based on their stage of development whether or not they're under whatever the age is for the child porn.
So I think this is where it would combine with the error in the jury instructions, because even if a juror, although I do think there's case law which says appearance alone is not sufficient, and I cited some SJC cases on that. I think this also does get to the instructional error, because even if they were permitted to do that, they were not instructed to do so. They were explicitly told that they could rely on her stated age, and that if she was above 14, that's it. They move on. It checks the box. An age which is very, I think, close to the line in terms of determining whether you're 14 versus 15 versus 16. In Massachusetts, I think freshmen are 14 to 15 and sophomores are 15 to 16. So where the statute is written the way it is, and we have Philopoulos, which requires this element, and we have a crime which involves no overt action beyond the mere sending of words, here sending of texts, there is an additional burden. And that additional burden was proving his knowledge or belief that she was below the requisite age. And I think that was, it would have been a very simple jury instruction going forward, and one additional element that they would have had to prove.
So let me ask you about that.
Yes.
The model jury instructions are not law, but they're certainly helpful. The notes to the model jury instructions for enticement say that when the crime involves a strict liability statute like rape or indecent A and B under 14, I'm quoting, the Commonwealth must prove that the defendant specifically intended to have sexual relations with or commit indecent assault on an underage victim, The Commonwealth need not prove the defendant knew the exact age of the victim, but must prove that the defendant intended to direct his sexual advances to an underage victim, i.e. to do a criminal act. Had the judge just read that, would that have sufficed in your view?
I think that there's a footnote in that jury instruction which cites to Philopoulos, which says that
I just read from that.
I remember, okay, maybe I'm remembering incorrectly. I thought that it specifically mentioned, and also raised that the Commonwealth concedes in its brief that the Commonwealth was required to prove knowledge below the age specified by the predicate offense. So I think that with regards to indecent assault and battery, so long as we're bound by Philopoulos, then
Perhaps that's in the indecent assault and battery instruction as opposed to in the enticement.
as opposed to the entire, okay, I think you're right, Justice Neyman, yes.
So to go back to my question, is the language I just read, would that have sufficed in this case?
If you had read that language and then when reading the indecent assault and battery instruction, which is the target offense they have to find that he intended, simply stated intended to commit an assault and battery on a person he knew or believed to be under the age of 14. I think that was the correct instruction, which should have been read but was not. That was removed from the jury's consideration. And as mentioned, Mr. Castillo was stuck with this conviction, which is a sexual offense, a very serious offense. There was an additional element which had to be met, but was not.
I think we're going to have to leave it there unless we have any other questions.
All set.
All right. Thank you very much.
Thank you very much. Attorney Jang?
Good morning. May it please the court, Kristen Jang for the Commonwealth. And I'm happy just to start at the jury instructions and to...
I would love that.
Yes, and to get to your question,
I'm
Justice
troubled
Blake.
by them.
Yes, so I struggled with this a bit too. So Philopoulos, however you pronounce that, the name, was a case where both the instructions and the instructions were erroneous and the evidence was insufficient. So in that case, obviously the conviction needed to be reversed. In this case, even if this court finds that the jury should have been instructed as the defendant suggests, I'm not sure that the correct remedy would be reversal. I believe it would be a new trial. And in looking for support on that, I was looking to Philopoulos, footnote 10. Towards the end of that footnote, the Emerald case is cited. And in the...
I think that's well accepted law.
Sure.
If we affirm the denial of the required finding of not guilty, but determine that the instruction was incorrect and
Yes.
prejudicial, then there's a new trial.
Correct.
Right. So can you go back to Judge Blake's question?
Let's stay with the instruction.
Sure.
You're not conceding that the instruction was problematic, but help me understand. The jurors were not instructed, as I understand this transcript, that for the target crime, the Commonwealth had the burden to prove that the victim was under the age of 14. And if that's true, how does this verdict stand?
So the jury was instructed that the defendant had to act with the intent to commit an indecent A and B on a child under 14, which under Philopoulos, it walked through the instructions in that case and it said up until this point, those instructions were proper. And that is precisely what was given in this case. I do acknowledge that in a perfect world, there would have been some sort of instruction saying that the Commonwealth was required to demonstrate that the defendant intended the object of his advances to be a child under 14. In a perfect world, that would have been given. Here, there wasn't that additional instruction that was found particularly problematic in Philopoulos, that the Commonwealth has no burden of showing the defendant's knowledge of the victim's age. So I think that is the important distinguishing factor here.
So here, I know he was found not guilty of indecent A and B for the thigh situation, but the jury, they were instructed on indecent A and B for that crime.
Right.
Is there any inference that as a result of the instruction, the proper indecent A and B instruction for which he was ultimately acquitted, that somehow that cures any deficit in the instruction on the target crime for the enticement?
Well,
It's a jump, I know. I'm just trying to test
Yes.
the limits here.
yes, and it is very confusing because there was a separate charge that has similar elements, right? So it's very confusing, but when instructing on the enticement, the judge did reference, I'm going to tell you about the elements of indecent A and B later.
But he didn't say under 14, what he said was, to
Right.
prove the third element of this offense, the Commonwealth must prove beyond a reasonable doubt by this indictment the defendant intended to commit the offense of indecent assault and battery, as I'm going to describe that offense to you shortly. He didn't say that there must be knowledge or it must be with the intent that the person be under 14.
Let me just, I have in my notes that he referenced 14, but that could,
It's at trial transcript volume 2, pages 95, 96. That's where the enticement instruction is, and then the indecent A and B instruction is at 98 and 99.
so I have at page 95, he says, third, that the defendant did so with the intent that he would commit the offense in this case of an indecent assault and battery on a child under the age of 14.
And then the judge looked below where he goes through the third element of the offense.
He used shorthand there. I will admit that he used, in my view, and especially because the jurors are listening to this audibly, right? They're not looking at this written. In my view, he was just using a shorthand there. But the first time the jury heard about this was in that section that I just read, where he does explicitly say a child under the age of 14.
Did the judge instruct in Philopoulos, if you know, similar to the language you just read on page 95? In other words, did the judge in that case instruct that the defendant did so with the intent that he would commit the offense of an indecent A and B on a child under 14?
Yes, that's exactly, I'm reading it straight from Philopoulos, that is exactly what was
So if it wasn't enough in Philopoulos, how can it be enough here?
Well, so I'm reading that section of Philopoulos. It walks through the jury instructions in that case. And it's the SJC said all of this was proper. And then it goes on to the rest of the instructions provided in Philopoulos, where the judge said the Commonwealth does not need to prove the defendant's knowledge of age, because that's what the judge was under the mistaken belief in that case that it was not required.
So that's the distinction.
That's the distinguishing factor in this case. And particularly given the facts of this case, the circumstances of this case, this was not a stranger case. The defendant knew this victim, and the jury had this victim in front of them the entire trial.
In the perfect world,
Yes.
how would we rewrite this jury instruction to avoid this issue?
I believe my brother's suggestion was appropriate. Yes.
Which was what? Say, run it by me again?
So perhaps it's just so confusing in this case because there was a separate A and B charge,
Yep.
but I suppose in a perfect world, it would be recounting the indecent A and B elements right after, in that enticement, and correcting that one element, whereas in the indecent A and B, it doesn't matter whether the defendant knew for that charge, but in the enticement context, there is that additional element. So I think
That he knew the victim
Believed.
or believed the victim was underage. So knew or believed would encompass an undercover police officer situation, where a police officer is acting online.
Yes, exactly. Precisely, Your Honor. That would be my suggestion. In a perfect world, that's how it should have gone. Again, this was so confusing because there was a similar charge that was underlying. I'm happy to also speak to the sufficiency case, and I think just given the nature of the defense in this case, all the circumstantial evidence that was presented, and one thing I didn't mention in my brief, but just as I was preparing for today, in the Commonwealth closing, she did describe the victim as polite, soft-spoken, young 13-year-old. Obviously, it's in the closing, it's after, it's after a required finding motion, but it just goes to how the victim presented. It's a little bit more circumstantial evidence, and the jury could have certainly made an inference based on that.
So if we think that the jury instruction is problematic, do we have to reach the sufficiency argument?
Yes. It goes to whether it was problematic enough to require a new trial. And if it was, then it might be a reversal if there also was not sufficient evidence. I would submit that the jury instructions were not problematic enough to warrant that, and there was certainly sufficient evidence here. And if there are no further questions, I'm happy to rest on my brief. Thank you very much.
Don't see any. Thank you. Counsel, this was an excellent argument, very difficult case. Thank you both. We are going to take a brief, approximate 10-minute morning recess. We will return with the civil list.
All rise.
session. Please be seated.
I just want to briefly repeat, because I know we've had some lawyers join us since this morning. As you all know, each side is permitted 15 minutes of argument. I know on this half of our list today, there are some folks that are sharing time, so I'll confirm those with each of you as we go, and there is no rebuttal. We have read everything, so you should get to the heart of your discussion. And I just want to make sure on our next case, Attorney Moriarty, you're taking 8 minutes, Attorney Myers 7 minutes?
Yes, Your Honor.
And then Attorney Reagan 10 minutes, Attorney Black 5 minutes. Is that correct? Excellent. Okay, so our next case is Maine Drilling and Blasting Incorporated versus RCS Behavioral and Educational Consulting LLC and others, docket number 23P1386. Attorney Moriarty.
Thank you, Your Honor. May it please the Court, Thomas Moriarty for the RCS entities. Your Honor, it's RCS's position that judgment should be vacated and the matter remanded for a new trial, excluding a claim for lost profits. The lost profits should not have been sent to the jury in this instance, Your Honor. The first reason is that Riverview did not properly plead lost profits or expectation damage in its papers. Yes,
Where
ma'am.
in the record does it say, or is there an inference that Riverview was going to be doing this without making any profit?
Well, Your Honor, actually, the question is really whether or not there was ever a contract between RCS and Riverview that contemplated lost profits. So clearly there was some portion of work that was performed on this job pursuant to a letter of intent. So
Was it foreseeable at the time that letter of intent was signed, was it foreseeable to the property owners and to RCS that Riverview expected that it would make a profit for its work?
It's impossible to know whether it was foreseeable between or among the parties that were involved, Your Honor, but the question is whether it was specifically contemplated between the parties. What Riverview admitted is that it understood that the only thing that RCS had ever approved in writing was the letter of intent, and that there was a cap with regard to the expenses under the letter of intent. So
Then, by the end of October, they'd exceeded that 84,000 cap, and Riverview kept working, and RCS kept paying the invoices that Cullinan approved. So isn't the whole course of conduct what the contract is?
Actually, Your Honor, the question isn't whether or not the parties could have formed a contract. Now, it's our position that the only viable claim for Riverview would have been an alternative theory to contract. But the question, if they even proved a contract.
But isn't that a jury question?
Well, Your Honor, the question about whether or not the parties contemplated a profit in a purported contract is a question for the jury. But there was no evidence presented to the jury that the parties had a contract that contemplated a profit claim. What's more, Your Honor, more fundamentally, just backing up to the original point that RCS was making, it wasn't pled in the case. So those questions, Justice Grant, could be relevant if Riverview had actually advanced a claim in the case for profit.
What's your best case in a flat fee construction contract case that says that under 5G, the plaintiff has to plead anticipated profits as special damages?
So I can't say that either of these cases is on all four points with the specific facts of this case, but I think that the most compelling cases for that principle of law would be the Anthony's Pier 4 case and the Boylston Housing Corporation case, both of which are cited in our papers.
But Anthony's Pier 4 was a case where the seller of the property backed out, and the developer, it was the plaintiff, and the owner of the property found someone else. So the special damages was going to be the developer's lost anticipated profits that they would have made had they,
Had we been able to do the work, here's what we would have made.
right.
Yeah, clearly distinguishable case, Your Honor, on the facts, but the principle is as apt in this context. The question with regard to whether or not the RCS was on notice that there was a claim that went beyond the $552,000 ad damnum that was advanced in the complaint remains relevant, because the underlying principle supporting that case is that we do not have trial by ambush in the Commonwealth. So the question was, in a circumstance where the complaint contains a consistent ad damnum, it's essentially a 6-count complaint.
What do you mean by an ad damnum?
A specific inclusion in the complaint of a monetary request for relief, Your Honor.
But isn't there case law that says the plaintiff isn't supposed to include that, a specific ad damnum and a statute?
Right. But the fact of the matter is there was a specific amount included in the complaint that did not seek profit, Your Honor. So you have a complaint that specifically says there was work done and billed. The work totaled $990. It was changed from the original complaint to the second complaint. And then there was a certain amount paid. And what we're entitled to is the delta between those two things, not the contemplated profit that might have been baked into a contract that contemplated, for instance, the 15% that Riverview would normally build into a contract. It's undisputed. The facts that went to the jury do not support the notion that RCS signed a contract that contemplated that 15%. What's more, Your Honor, that 15% would have been gross profits on the deal. In order to be entitled to any profit in this case, there would have to have been evidence of the net profit, that which RCS purportedly denied as a recovery to Riverview.
But isn't the 240, the 15%, just the benefit of the bargain for Riverview?
No, Your Honor.
Why not?
Because there have to be facts that support it in this case. The jury had to be presented with facts that would have allowed a causal connection between a purported breach of contract and the recovery of some net profit. So what that 15% is essentially a statement of what Riverview would have built into its contract had RCS executed the proposal.
That gets to my question, if I may, which is, you submitted a proposed lost profit instruction. Yes?
RCS objected
there was a request for instructions, and one of them was on lost profits. I understand you objected to that going before the jury, but yes, you did have a proposed instruction. And the instruction, and you also make the argument that the judge had to instruct the jury, if she was going to give a lost profit instruction, that it required finding that lost profits were fairly within the contemplation of the parties to the contract at the time it was made, caused by the defendant's breach, capable of proof with reasonable certainty. And you cite the Liberty Bay Credit Union case. It's a federal case. But that case is governed by New York law. What Massachusetts case supports that proposition, that those three elements had to be met?
Your Honor, we were not able to identify a Massachusetts case with regard to those elements.
Are there any Massachusetts cases that explain what should be given in a lost profits instruction?
Not that we were able to cite to the court, Your Honor.
Okay. Thank you.
Thank you, Your Honors.
Thank you. Attorney Myers. You represent Northside, correct?
Correct.
May it please the court, Edmund Myers for the appellants Knobscott and Northside. To get right to the point, we're looking for the panel to overturn Judge Campbell's decision validating that there are two apt mechanics liens in this matter, essentially because the agreement that Riverview is relying on within the mechanics lien doesn't meet that rigorous, strict compliance standards set out in Chapter 254. Specifically, Riverview relies on the letter of intent, which you already heard some issues about. And that letter of intent does a couple of things. Initially, the owners give consent simply to discuss another agreement, and it references that Riverview and RCS will enter into a more formal agreement, and it sets out what yet has to be determined. And that includes some value engineering and details about the construction. And that refers to another formal agreement. Then there's some strict specific terms in the agreement which say items 1 through 6 of the proposal, and this is important, that's the only time this proposal is referenced. Only those items, and only those items are adopted in that proposal.
What about work is to be initiated as soon as possible, and if the project is placed on hold for reasons not in the contractor's control, he shall be compensated for the costs he's incurred to the point of stoppage. So that sounds as though your clients and all the parties knew that this was going to move forward quickly.
Well, I don't think they knew. I would say they anticipated, but that language would apply to what and it only can apply to what had been agreed to be done at that point, which was items 1 through 6 with a cap of value of $84,000, roughly $84,000.
But wasn't the jury instructed that they had to decide whether the contract was what you're saying or whether it was the whole course of events?
They weren't instructed that specifically. What they were instructed was to determine whether there was a breach of an agreement. And there's a difference between finding the contract that the jury had found in strict compliance with the statute. And I'll put it this way. Riverview was well aware they needed a second formal agreement because that's what's in the letter of intent. You need to get another agreement. Riverview decided not to do that, and essentially, as you can see from the record, relied on a series of invoices to establish that. Now, that may have established a second agreement, but that's not the agreement they reference in the mechanics lien. They reference the letter of intent, which is limiting, and not those invoices. They certainly could have said or referenced the letter of intent together with invoices set out. It's cumbersome, but that's the choice they made.
Is your argument, in essence, that there is no written contract within the strict meaning of General Law, Chapter 254, Section 2, to the extent that the LOI constitutes that written contract, then the mechanics lien is limited to that $84,500. Is that, am I restating your argument correctly?
Correct in that it's limiting, but I would go one step further that the agreement didn't comply, but even if it does, that's not the agreement that Riverview references in their mechanics lien to their folly. And that goes back to the strict compliance of 254. And if I could just comment on the proposal that's referenced, and again, it's referenced only for that limited 1 through 6. The proposal was part of the appellate record, and that proposal itself has 2 separate values and work descriptions. Essentially one with blasting, which was $300,000 more than the first, so it's 1.2 versus 1.6. Additionally, MAINE cites, and I found this interesting, MAINE cites in their opposing brief that the principal of Riverview testified that RCS was determining at some point whether to hire their own blasting company, contractor, rather than MAINE. And the reason I think that's important is that there was no meeting of the minds at the time that letter of intent was signed. That I think it's August 17th of 2016. Contemplation of a future agreement with many details to be worked out needed to be addressed. And ultimately, you can argue the jury may have found that. But if they did, then that's the agreement that Riverview should have referenced when you're dealing with the benefits of Chapter 254 in encumbering a property. And that's why the strict standard is available. And those limitations and that non-meeting of the minds, no contract formation, was essentially not addressed by Judge Campbell. She just went right into it. Well, this is kind of a standard case where you had some initial agreement, then a series of invoices, and here you go, here's your writing. But what she failed to address was the statement within that agreement that says, hey, look, we don't have an agreement at this point. And you can look at it a couple of different ways.
Before you do that, though, a more fundamental question I think I have is, it seems that you don't agree on what our standard of review is on this question.
I was
Can you
going to
address that?
I will. When I first saw that, I looked at 15A, and essentially that was uncontested documents upon review in order to get to the summary discharge. And I know that there was a question of clearly erroneous fact. In this particular matter, if you examine the judge's memorandum, she cites that the proposal which she incorporates states it was incorporated by reference in the letter of intent. But our argument, as I stated earlier, is that really didn't happen. Only 1 through 6 were referenced, and the rest, regardless of what it was, had yet to be agreed upon. So just from the 4 corners of the document, however, even if you look at it from the clearly erroneous standard, given the information in the argument, I would argue that I know that's a more rigorous standard. Even under these circumstances and that standard, the finding that the mechanics lien is valid should be overturned.
So under either standard of review?
Either standard, I think it's clear enough so that that's the case. And with that, 7 seconds left, unless there are further questions.
I don't see any. Thank you so much.
Thank you.
Attorney Regan, on behalf of Riverview.
Good morning, Your Honors. I'll start with Knobscott, if I may. The standard of review is clearly erroneous. In this case, Judge Campbell found that the entire contract, as found by the jury, was incorporated, at least for notice purposes, in the letter of intent which was put on file. This is all put on file after the progression of billing and payments and all the other things, the documents that make up that contract. And the point of notice is to tell the other party, what are we talking about? What contract are we talking about? Everybody knew. So it's certainly not clearly erroneous that she found incorporation, as that's exactly what the jury found. The jury answered the question, was there a contract for $1.6 million? They answered yes. The fact of the contract here is factually settled by the jury and by Judge Campbell. And Judge Campbell's ruling naturally flows from that. And all the other details that my brother is pointing to on, what the letter of intent said about agreeing to agree further, I don't think that that's the issue here. Judge Campbell made a determination. It's not clearly erroneous. It's perfectly in agreement with the jury. So I would suggest that you should uphold that ruling.
So your argument is essentially that the LOI plus the proposal plus the course of conduct is sufficient to satisfy
Yes.
Chapter 254, Section 2. What's your best case to support that proposition? Best Massachusetts case?
As far as a specific case law, I don't have that, other than to say
I'll take any case that's remotely close, that says, okay, this is good enough, close enough to constitute what we mean by a written contract, et cetera, within the meaning of Chapter 254.
I believe, first of all, Your Honor, I don't have a case fresh that I could cite. I believe I've cited the cases in my brief indicating that you don't have to have a single integrated document. The assemblage of various documents can constitute that. And if I had the case of Jones versus Smith saying so, I'd give it to you. I don't have that in my head. But again, it's a factual determination. And there's nothing, if the jury was entitled to make the finding it made, and I believe Judge Campbell was echoing exactly that same finding. With respect to RCS's argument on the jury instruction, I note that one of the cases they cite, Oilston Real Estate, actually goes back and cites old Hadley v. Baxendale, first-year contract class. There's absolutely nothing more basic than benefit of the bargain, putting a breached party in as good a position as he'd been before. It's interesting that if you read the language of Judge Campbell's instructions, she said, now I'm going to give you the instruction based upon price. And she gave the whole thing. Now I'm going to give you the instruction based upon profit. It was exactly the same instruction. It was exactly the same instruction. My brother says that profits are inherently a special damage which you have to plead specifically and jump through all the other hoops he's raised for me. The fact is that, and he admits in his own brief, those profits are those that are not naturally and ordinarily the result, they flow from the cause of action. So when you have a legal malpractice case in which the party's money's tied up because the lawyer did a bad job and lost the case, and that person wants to get profits from a project he could have invested in if his money had been free to go, there's a special damage. But in Boylston...
When is the first time that you or your clients alerted them to the 15% kicker, let's call it?
I would say it's probably a couple of years before trial, which is when I got involved, and I tried to clarify that we would be pursuing all aspects. In some deposition, some place or another, we were talking about
We're going
this.
to find in the record somewhere about the 15% approximately 2 years prior to trial?
No, this was just conversations among counsel. There's not
In the
a...
record, can we find the first indication that you were seeking the additional 15% on behalf of your client?
I'm not seeking
Where
it.
was that first presented to the other side? Where in the record can we find
I would
that?
suggest it's in the very nature of the complaint from the beginning, alleging the breach of contract. What my brother has pointed out with the ad damnum matter is that before I got into the case, it was drafted in such a way that you didn't pay these X payments. And I tried to correct the fact that we're not limiting the claim to the unpaid payments. We were including the entire value of the contract. And that was just conversation
Which was
among
set
counsel.
forth as $552,000. It was 561 and then 552, right? In the
Yeah, the
complaint?
500 some odd was the total of the unpaid billings. And
And that's the amount that was put in the complaint, and the amended complaint was then, I think, 552, and then...
I believe that's correct, Your
And
Honor.
that's the amount that was disclosed in response to interrogatory requests?
I believe that we noted those as the unpaid payments. I don't know that in our interrogatory answers, there was any further, I don't think there was a discussion of profit. But again, I would submit, Your Honor, that it doesn't require separate notice when you are dealing with a fixed price contract and the whole principle of the benefit of the bargain.
I have a question for you about the record.
Yes.
Before your closing, you had a discussion with Judge Campbell about a chalk that you were going to use and the wording of a chalk.
Yes.
Is that chalk in the record?
It is not.
So it wasn't marked for ID? And so we don't have any way of, without trying to reconstruct it from the transcript?
What I would suggest, Your Honor, is that that chart is pretty much replicated in my brief on page 10, and it simply lists out the invoices, the payments, the dates, and so forth. That was just to make these numbers, which everybody had heard and seen on paper, assemble them a little bit better. But the chalk itself is not part of the record. This is essentially the content that was in that chalk. You know, my brother also contends that we did not present evidence of a contract sufficient to warrant the jury's finding.
So do we know how the jury arrived at the 530-190 number?
It's not clear. It was not specified in the verdict.
So that's not something that can be inferred or surmised from anybody's closing or the chalk or something? As to
No,
how
that
they
number
arrived
was
at it?
not, that number was definitely not in the chalk.
It might have been that they came to a number and then they rounded up or rounded down because they liked your tie or something.
Thank you, Your Honor. I've tried to back into the number they reached as well with a lot of arithmetic and so forth. I can't exactly find it. But they did not specify that in the verdict. It's a reasonable approximation, I would say, but again, on the question of whether or not there's adequate evidence to support the verdict, I would just respectfully refer you to the brief in which I've tried to go item by item through the subjects that RCS says were not sufficiently addressed. Another matter is they say that Riverview waived the breach of contract claim, and now I'm in an interesting position here because the case law on that provides that you have to also specifically plead waiver and have it specifically decided at the trial, and that never happened. And in any event, the testimony of Mr. Ross is to the effect that he believed in good faith these people would get back on their feet, and that did not happen. But, Your Honor, again, we respectfully request that you uphold the verdict and uphold Judge Campbell's rulings for the reasons we've detailed.
And you're seeking fees?
Seeking fee? No, I have not. I have not put an action in for fees, no.
Okay. I might have misunderstood. Thank you.
Thank you, Your Honor.
Attorney Black.
Good morning, Your Honors. May it please the Court. My name is Lindsay Black. I represent the plaintiff appellee Maine Drilling and Blasting, Inc. in this case. So I'll get right to the point considering my time constraints. Both appellants ask this court to overturn factual findings by the jury and the trial judge, who were in the best position at trial to judge the weight and credibility of the evidence that was presented and whose factual findings are afforded a high level of deference on appeal. I ask that you affirm the findings of the jury as well as the trial judge. So I'm going to address two key issues. First, the jury properly found that Maine Drilling and Blasting proved it performed drilling and blasting work at the Framingham, Massachusetts properties. The unpaid value of that work was subsumed within Riverview's breach of contract claim against RCS. And second, the trial judge, as fact finder, properly found that Northside Knobscot, as the property owners, was a party to the $1.6 million written contract between RCS and Riverview, and as such, denied Northside Knobscot's motion for summary discharge of Maine Drilling's mechanics lien. So with respect to the RCS appeal, all I really want to address on the RCS appeal is the fact that RCS does bring Maine Drilling into their appeal at one point. So they do say in their claim that Maine Drilling failed to prove it performed its work on the project under the subcontract with Riverview. I just want to note that that is clearly not supported by the evidence in the record. As you review the record itself, Maine Drilling's work on this project was documented through customer acceptance slips, blast reports, and invoices, all of which were in evidence at this trial. In addition, the blasting reports in particular, the law requires that Maine Drilling fill those out within 6 hours each and every time they blast at a project site. So those are as contemporaneous as you get from a document perspective. Those were also, again, in evidence, and the jury heard from Andy Dufour, who was Maine Drilling and Blasting's witness about the nature and the work that was performed at the project. So that was provided in great detail to both the jury and the judge.
What is your best case for the proposition that the documentation here constitutes a written contract within the meaning of General Law, Chapter 254, Section 2?
I would assert two things. One, I do have a case for you, Your Honor, but two, the trial judge laid out a number of cases to support her position in her order as well, based on Massachusetts law. But one of the cases that I have for you is Harris v. Moynihan Lumber of Beverly, and it's noted by the judge in her memorandum in order. And specifically, that case says that a series of detailed documents with essential terms taken together do actually constitute a written contract under the mechanics lien statute. And I did want to note something about Chapter 254, Section 2A, excuse me.
You cite that in your brief, right?
Harris versus Moynihan Lumber of Beverly. I do not recall, Your Honor, if we doubled down on that case in our brief, but I do know that it is referenced by the judge.
That's your best case for that?
Yes. And the one thing to note, Chapter 254, Section 2A, does state that a written contract under the mechanics lien statute is a contract that's enforceable under the laws of the Commonwealth of Massachusetts. So again, under the laws of the Commonwealth of Massachusetts, and this is the argument that Judge Campbell made in her brief, and she detailed it quite expansively, but under the laws of the Commonwealth of Massachusetts, this contract and incorporation of all of these documents, including course of conduct, the invoices, the checks that were paid by RCS, the fact that, and Judge Campbell notes these things when she notes as to why she holds that Knobscott is a party to the $1.6 million contract. She references Knobscott's participation via Robert Foley, their project representative or their property representative, in the creation and the execution of the letter of intent at that time, as well as his receipt of the proposal. He knew about the proposal at the time. He knew that the proposal included additional work beyond 1 through 6. Also, the letter of intent does have language that says to include items 1 through 6 of the proposal, but it does contemplate additional work as the project is continuing. Robert Foley also knew that blasting work was being performed, which was outside of those 1 through 6 scopes that were listed in the proposal, but was within the overarching scope of the proposal that was put before Knobscott. He knew that the work was being performed by Maine Drilling and Blasting. He knew that it was done at that time by a contractor through Riverview, and that it was not done via hiring directly from RCS.
Judge Grant has a question.
Are you the same lawyer who represented Maine Drilling and Blasting at trial and gave the closing?
I am, Your Honor.
A different last name?
Yes.
Okay.
Yes, I got married, Your Honor.
I was confused by that. In your closing, you referred to Maine Drilling and Blasting's invoices, which is now marked at Exhibit 43 in your binders. My question is, in the record appendix, after what's labeled Exhibit 43, there's nothing. It's RA Volume 4, page 123. It just says Exhibit 43, next page, Exhibit 44.
There's no documents in the record, Your Honor.
Correct. But there is, later, there's some invoices and firefighter time slips and things from the town of Framingham for Maine Drilling and Blasting later in the record appendix. But I'm just wondering where that exhibit is that you referred to in closing.
The exhibit does exist, Your Honor, in the trial court's record. If it's missing from the appendix that was compiled by RCS in this, I apologize for the oversight. I do...
Afterwards, why don't you have a conversation with counsel if you can all agree to file a supplemental appendix? I'm sure we would take that. If there's a disagreement about it, you can file the appropriate motion and it'll be directed to the panel.
That I understand and I agree. Thank you, Your Honor.
Okay, thank you very much, counsel. Thank all four of you. This is a tricky case and it was well briefed and well argued, so thank you all very, very much.
Thank you, Your Honor.
Our next case is the Department of Children and Families versus Child and Another, docket 23P 1360. As counsel approaches, I remind you that the case is impounded, so please do not use any names. Attendees. All right, and just so I'm sure of this, Attorney Eisenman and Attorney Diaz, you are sharing your time 7.5 each?
Yes, Your Honor.
Wonderful. Attorney Eisenman, when you're ready. Good morning.
Good morning, Your Honors. May it please the Court, Lynn Eisenman on behalf of Father. Father is asking that you vacate the decree that terminates his parental rights and does not order post-termination or post-adoption visitation between him and his son. So essentially, this case comes down to whether the court should have terminated parental rights. Here we have a 15-year-old boy who did not want to be adopted, a young man...
Well, he is kind of equivocates about that, doesn't he? At times, he says a lot of things about what he wants. So I don't know if that I can fully agree with you. I think there are times he expressed he didn't want to be adopted, but I don't know that that's the...
Well, I think at trial, abbreviated as it was, the judge did make an acknowledgement that that at least at that point in time, the child's position was that he did not want to be adopted. And certainly understanding over the duration of these cases, children are going to change their minds based on placement or whatever the case may be.
I realize that you want to talk about the termination, but I'm wondering, since we're talking about the child and his age right now, you make an argument that, and these are my words, not necessarily yours, that this case was rushed to avoid the consent piece of his age. I understand the advocacy argument there, but what do we have in the record that says that the department rushed this case to avoid having the child have to consent to the adoption?
So I wasn't necessarily arguing that the department had rushed the case. The rushing was really the judge's decision.
And I have lots of questions for counsel from
Sure.
DCF about that. Be ready. But you do argue that there was a rush, and I'm trying to understand.
It's more of the child was not in a pre-adoptive placement. So there was nothing really to lose by not terminating. So if dad is given another 6 months and he wants to come back for review and redetermination, or at that time if he's not engaged further, the department wants to come back in for review and redetermination, that's one of the criteria for the judge to look at in terminating is whether a child is in a placement where that's a prerequisite. And it doesn't have to be, certainly. But
So in terms of sort of the placement options, and I know your sister counsel makes an argument about him being a legal orphan, which we know the case law does not support, but DCF seems to me, at least at the time that this record was assembled, to be doing a lot to try and figure out actually if we can have a kinship placement, which is short of being placed with a parent, to me, is always the next best thing.
Sure.
And so on the one hand, I understand the sort of the legal criticism about the plan, but on the other hand, they're not rushing to post him with mayor and recruit. They're really trying to figure out, maybe this is better asked to Attorney Diaz. So, what is the abuse of discretion when the judge had information that we're still trying to figure out how to keep this kid in a kinship placement if dad's rights are terminated?
So I think it's more of what kind of, and I can certainly defer a little bit more to Attorney Diaz, but in the plan, what kind of a home was the department looking for? So what were the characteristics of the home? At least from my perspective, that's the issue that I take on behalf of father with the plan, that we did have information about the child and his needs, but then what was the department really looking for as far as a placement resource? And to their credit, absolutely, they were looking at kinship placements, and unfortunately, I think there were 2 that just were not options for various reasons. But that is one of the requirements that the judge has to consider in terminating is what is the plan, and is it detailed enough for him to know and have confidence that that termination is in this child's best interest.
On the issue of the conclusions of law, or the lack of them.
Yes.
We certainly all have seen more findings and conclusions that any of us can probably count at this point, and they often do set out the 210 statutory factors, and there's a conclusion, and there's usually a sentence or 2, or it says not applicable or something. And while I would agree with you probably every day of the week that that is the best practice in these types of cases, does the statute, or is there a case that says that such explanation is required in that particular manner? Or does the sort of summary way that this judge handled it by saying, I've considered them and it's inherent in my finding, it may not be best practice, but why isn't that sufficient? Is there a case that says otherwise?
So I think, so adoption of Larry, which is 434 Mass 456 from 2001, in that case, the court said the judge was aware of the factors and specifically stated that he considered each. He made specific findings as to the 4 factors that he determined were applicable and said nothing of the others. That is all that was required of him. So, drawing an analogy, at least the judge has to say which factors did he find applicable. So, Yes, certainly in all of the, in multitude of findings that we've seen, each one is laid out, but I think at a minimum, if he says, you know, number 2 was applicable and this is why, number 7 is applicable and this is why. But again, we have absolutely no conclusions of law to even know what standard the judge applied. And so review is, quite frankly, impossible to, to some extent, to know what law was applied by the court in reaching his decision. And if I could just touch briefly on the issue of post-termination and post-adoption visitation, again, I take the same issue with the lack of conclusions of law and what law the judge applied. We don't know what law he applied, but he did say on the record at the end of the hearing that he really couldn't make any order for post-termination and post-adoption visitation. Instead, that all really he could do was encourage the department to follow the child's wishes. So I would suggest that's not the law. The law is what's in the child's best interest. And then the findings also state the incorrect legal standard to the extent that they say that the judge found there was insufficient evidence of continued contact between dad and the child. And again, that would be the incorrect standard. So my time is running low, so in conclusion, I would just ask that the court vacate the decree, unless the panel has any other questions.
I don't see any other
All right.
questions. Thank you so much.
Thank you very much.
Attorney Diaz.
Good, still morning. Yes.
Still morning.
Good morning, Your Honors. Myrna Diaz on behalf of the child. May it please the court. Your Honor, Your Honors, we're here today asking this court to vacate the decree terminating father's rights, the order not allowing for post-termination, post-adoption contact, as well as the adoption plan, the insufficiency of the adoption plan. Currently, my client is 16 years old. He is in the 11th grade. He's doing rather well. He has an internship at a bank. He has been in the same intensive foster home since March of 2022. So that's where he has been. I know that Your Honors were asking about, at the time of trial, that he tended to go back and forth, which is why originally there was no notice of appeal, and then I had to file a late notice of appeal. The issue was that at trial, or right around the time of trial, there was conversations regarding him being placed with a maternal aunt. And unfortunately, that fell through. So he was then placed in this current home where he has been. And he did, it's in the record that he did express that he did not want to be adopted if he could not be with a family member. So I think at the time of trial, he did not want to be adopted, but there was a glimmer of hope that he could be with a family member, then he would have felt comfortable with that. As to the post-termination, the lack of an order for post-termination contact, in the judge's findings, he did state that it had been a month since my client had contact with father. So that had only been 1 month. Before that, there were visits that went very well, very much enjoyed spending time with father, and I believe the judge also made findings as to the visits, and it's in the record that there was testimony as to how well the visits did go with father and child.
So was the last time your client saw his father roughly June of 2023?
Yes, May or June of 2023. And most recently, I did meet with him last week. He still had unfortunately no contact with his father. But he does very much want to have that. He does have visits with his mother, and that's because mother, she stipulated and signed an open adoption. So he does have visits with mother, but wants to also have them with his father. The issue,
As far as your point about your client does not want to be adopted unless it can be a family member.
Yes.
Well, the statute 210, section 2, says that because he's over 12, he can't be adopted without his written consent.
that is correct.
But so does that really affect the decision about whether or not termination is in, he doesn't, the statute doesn't provide that he has to consent to termination, just to adoption.
That is correct. So they don't necessarily go together, but an analysis on behalf of the judge would have been helpful to go through the 210 analysis when considering if it was in the best interests for the termination piece, as well as what the adoption plan should look like for this child. And, sorry, I'm just going through my notes. So sorry, does anybody have any questions before I continue?
I don't see any.
Okay. So the issue regarding the adoption plan itself, it was not necessarily, it was not detailed enough, did not describe enough what the characteristics of what this child, of what my client would particularly need, what kind of home he should be placed in.
How does that weigh against that the department was still looking at a kinship placement? Does what the home, I certainly understand the importance of the characteristics when it's a non-kinship, but does that give way when we're looking at a kinship placement? Is it as important?
It is important, just to make sure that not any kinship home is going to fit any child.
It needs to be safe and appropriate.
It needs to be safe and appropriate, and it needs to be in a home that fits with this particular child. So this particular child, I believe this is in the record as well. So he needs an IEP, he has different needs, and none of that was included in this adoption plan. It was more of we're exploring a kinship placement. If that doesn't work, then we're going to put in a recruitment plan and kind of just put it out there and see if he can be adopted. So that would have been a finding that the judge should have considered before allowing the adoption plan to go through. If the panel doesn't have any more questions, I
don't think we do.
Okay, I'll rest on my brief. Thank you.
Thank you very much. Attorney Braithwaite. It's never good when Justice Neyman's pulling a book off the shelf.
I look forward to the challenge. I will wait, though.
Please go ahead.
Members of the panel, may it please the court, I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decree issued by the lower court. There was abundant evidence that father was unfit, that he was unwilling to avail himself of the services offered to ameliorate his parental deficits, that it was in the best interest of the child that his parental rights be terminated, and that it was not in the best interest of the child to enter an order of post-termination or post-adoption visitation. The court's decision in this case was the right one.
So, it's not giving you a hard time, necessarily, but I am really struck by this written decision and the comments that this judge made at the end of the trial. And I would not endorse this this type of action in any case. We still have to look to whether or not the evidence supports his ultimate determination. But I think what I'm struggling with is the 210 conclusions, and I appreciated Attorney Eisman pointing out Larry. I mean, here, all we have it's under the adjudication, paragraph 2 is, I have considered the father's ability, fitness, and readiness, as well as the 14 factors set forth in 210.3c. He's considered them. We don't know what he thought about them, what applied, what didn't apply. And so then I go back to the text of the decision to see, can I infer it? Can we pull it out? The decision itself is really just a recitation of the facts, which is not unusual when you have both findings and conclusions. Why is this enough?
Well,
For starters, just in response to adoption of Larry, I would also like to direct the panel to adoption of Darlene.
Of which one, Darlene?
Darlene, because in Darlene, despite not stating which factors applied to the case, the judge expressly cited the statute and the court rejected the parents' arguments that the judge had failed to consider them. So in Darlene, citing the statute was enough. And I would state that while the trial court is required to consider the 14 statutory factors, it is not required to do so via conclusions of law. And I'd love to direct the panel, if I could, to ways in which the court's explicit findings specifically fall into factors, because I think that the court's findings, in fact, do respond to the factors they were meant to search. The court made extensive findings that the child and his siblings had been neglected as a result of father's acts or omissions, and that he was offered extensive services intended to correct the circumstances, but refused to utilize them. That is factor 2. The court made findings that the child had been out of father's custody for more than 6 months, and his contact with the child was inconsistent, including failing to see the child at all for over a month at the time of trial, and further, that father failed to accept or productively utilize services intended to correct the circumstances. That is factor 3. The court made findings that the child is older than 4, has been in the department's custody for all of the immediately preceding 15 months, and that the child cannot safely be returned to the father's custody, despite father having been offered services intended to correct the circumstances. That is factor 4. The court made findings that without excuse, father failed to provide proper care for the child, and despite having been offered services intended to correct his circumstances, he refused to avail himself of such services, and there is a reasonable expectation that he will not be able to provide proper care within a reasonable time. That is spelled out in his factual findings. That is factor 6.
So not the model of clarity, but if you take the findings and you were to sort of overlay, if you will, the statutory factors, we would get there.
Yes, and I don't want to take more of the court's time than I need to, but I would just say that factors 8, 10, and 12, I would argue, are clearly fleshed out in his findings. So the requirements of factors 8, 10, and 12, in addition to those I just mentioned, the findings answer that that was met. And I would also, if I could go on to just say, several of the findings of fact themselves contained conclusions of law embedded therein. I direct the panel to finding 19, where after identifying the extensive history of domestic violence between the parents, the judge concluded that witnessing this kind of violence has detrimental impacts on children. And he even cites there the custody of Vaughn. Finding 23, after identifying father's ongoing criminal activity, concludes that it is unlikely that he would be available to care for the child on a long-term basis before being arrested and reincarcerated. Again, without wanting to take too much of the panel's time, I would direct you to findings 39, 45, and 50, where similarly, if you read the finding in whole, you'll see that there is a conclusion embedded within.
So let's go to sort of what happened at the conclusion of the trial, and we know Dad did not appear for trial. It was a short trial. That's in and of itself not that unusual, but there were a significant amount of documentary exhibits that came in, and the judge seemed to say, basically, I'll be back in a couple of minutes with my decision, which leads one to at least make the argument that there's no way he could have reviewed all of those exhibits and had them part of a considered analysis when he came back and said, I'm issuing a decree terminating. What do we do about that?
Well, I think that while we cannot know with clarity what the judge specifically was able to review before making decision, the record does reflect that the judge had ample evidence to reach his determination prior to making it. The social worker testified to father's parental shortcomings, his refusal to engage in services to overcome them, his homelessness and refusal to accept a shelter placement, his inconsistency in visits, the child's lukewarm feeling towards him, and father was called to testify but chose not to because he refused to step foot into the courtroom. So the court did not hear from father to rebut any evidence. There were no challenges made to the department's evidence, and by the time the trial had concluded, the court had sufficient record evidence before it to find that father was unfit and not temporarily, and also that it was in the child's best interests that his rights be terminated. I would also argue that the testimony put forth regarding visitation was more than sufficient sufficient for the judge to find that it wouldn't have been in the child's best interest to make an order of post-adoption and post-termination visitation. I know my sisters point to the fact that there is statutory authority for a judge to make such an order, but that is contingent upon a finding that it is in the child's best interest. If it is not, the judges are stopped from making such an order. They cannot do so. Here, while there is evidence that visits when they happened went well, the visits were incredibly inconsistent. Father did not meet at the outset of the case. He was consistent for roughly a period of 3 months, and it's indicated that even though that was relatively consistent, there were missed visits, there were late visits. Then after those 3 months, he simply didn't visit no, I'm sorry, that's not correct. He missed 70% of his visits over the subsequent 6 months. Regularly, Father would attend over an hour late or upwards of an hour late for 2-hour visits, and the department policy is not to allow a visit at that time, but the department nonetheless would. And I know that there were potentially issues of transportation, but there was evidence that the social worker communicated with Father around whether he required support for transportation, and he did not seek support for transportation. So the visits were not evident of a great relationship. The court actually made an explicit finding that there was no evidence of a bond between father and the child, and this is not the same as other cases where we've had no visitation be problematic. Here, this child had other connections. He was visiting regularly with maternal aunt. She was in placement for a period of time, and though that didn't work out, they were meeting. He has siblings who he was visiting, and he also was visiting and continues to visit with his mother. So this isn't someone who had one caretaker with whom they had a bond, and that was Father. In fact, there was no bond found with Father, and he had other people that he was visiting with. So I would say there was a lot of evidence before the court put forth in that short time.
I have a question about his age. Hypothetically, if we were to agree with Attorney Eisman and Attorney Diaz and vacate the termination and remand it, at that point, would the child have to consent to the adoption?
No, consenting to the adoption is not required in order for a termination to stand. And I'd
The termination could still go forward. Then the question would be what happens next?
Yeah, and I would specifically ask the panel to consider adoption of Nancy here, because we had an adoption of Nancy, 2 children whose plan was not adoption. In that case, they were stable. They were residing with kin. Wasn't the exact same fact pattern as we had here, but there were a lot of similarities. We had a parent who had substance abuse issues, had many, many, many opportunities to work towards ameliorating those issues, and chose not to do so. The SJC, in reviewing that evidence, said, even though these children are not going to be adoption, the statute's very clear. The statute does not require that adoption is the permanency plan in order for termination to be in the child's best interest. Here, the reason the termination was in the child's best interest, even were adoption not on the table, is because this child had spent years in the dysfunction of this family. This child observed years of domestic violence between father and mother. It would not, I know my sister indicated that there was nothing to lose by not terminating these rights, and that the father could go back for a review and redetermination, but our case law doesn't agree that there's nothing to lose there. That is incredibly destabilizing for a child. I know it's used a lot, but I like the sentence in Nancy. I think it applies here. At some point, you have to say enough. This court found the father had made no efforts to improve his situation. This court found it was impossible to imagine a scenario where he would. This child benefits from the permanency of not having to be engaged in protracted litigation, of knowing what rights exist and what rights don't, and now navigating.
What about post-termination visitation, though? Why isn't that in the child's best interest, if that's what the child wants?
Well, the child did not indicate wanting that early. So I recognize that's what the child wants now. As far as why it's not in the best interest simply because he wants it, I think because the child is, we often see in child welfare cases, children want connection with parents, whether it's good for them or whether it's not. We have evidence that father, and the record, was profoundly unwell. He attempted suicide on multiple occasions. He tried to put, I believe, Ativan into his jugular, crack cocaine into his neck. I don't say it to draw attention in a wow way. I say it to suggest it isn't in the child's best interest to count on something that may or may not come through. Father has historically been hospitalized. Father has historically been transient. Father has resided in a tent. He's moved it for various reasons. I don't say that to judge Father. I say that because it speaks to whether or not Father would appear at a visit. One of the things the court looks to in determining whether it's in the best interest of the child to put an order in place is how that order will play out in the child's life. If it's safe to assume that Father is going to show up and it's going to benefit the child, then maybe it is in his best interest. But in that case, the child can ask the department for a visit. I know my sister indicated that child wants a visit, and I don't know if the panel would like me to go beyond the record, but I can certainly indicate child has not requested a visit, nor has Father since the termination trial, nor has there been phone communication, which is permitted. So there has been zero contact between Father and child in this time. Child, also there was testimony that while child did not refuse visits, he had a changing attitude towards them. He did not necessarily want to go to them. So it wasn't the case, and I would point the panel to adoption of Willow. We are looking at the cases we are looking at the facts that were before the judge at the time the judge made this decision, and that's adoption of Willow. And the facts at that time were that the child was open to adoption. The only mention in the entire record that child did not want to be adopted was when the judge made a comment in passing while conducting the colloquy with mother for her open adoption agreement. And I'm not discrediting that that is a legitimate part of the record, but there are other parts of the record where a child says he neither wants to be adopted nor does he ever want to live with his parents. He wants to live with one parent. He doesn't want to live with any. He wants to live with kin. So he's understandably going through a lot, and this is why our case law says that children's views are mutable. They should be viewed as mutable. We should do what we can to ensure they have the best possibility of adoption in the hopes that that becomes an option. But even if it doesn't, for this child not to have to relitigate or potentially be re-traumatized by his father's instability is in his best interest.
I don't see any other additional questions.
Thank you, Your Honor.
Thank you. These are very difficult cases. It was very well argued. Thank you all. It is under advisement. Our last case today is MB versus AG, docket number 24P291. This case is partially impounded, so I would ask counsel not to use the names of the parties. Just a moment, we got to get everybody set up. No one's splitting time, right? Someone's sitting with you.
Correct.
Okay. When you're ready, counsel.
Thank you, Your Honor. May it please the court, my name is Paul Lewis, and I represent the defendant appellant AG. Today, the defendant is primarily asking this court simply to remand the case back to the lower court after the lower court incorrectly denied a motion to vacate due to a plain and simple jurisdictional error of law. This is an error of law. Accordingly, it's given de novo review by this court. So,
at any point, did you ask the single justice of this court for permission to file the motion for relief or for it to be heard? In other words, after Judge Kunis denied it, saying you didn't have jurisdiction, it's not uncommon, certainly in probate court matters, that things are changing on the ground all the time, and when something's on appeal, parties come here to the single justice and request permission to proceed below. Did you do that?
no, Your Honor, I did not do that. Instead, because the direct appeal 2023 P0286 was pending, I immediately gave notice to that particular panel that this had occurred and that it was under advisement pending at that point, and that I intended to appeal. So I asked for a stay, and then I informed the court that I intended to appeal and then move to consolidate. That stay motion and subsequently the motion
But rather than having to do this sort of second appeal, I'm just asking whether you contemplated getting permission to have Judge Kunis or a district court judge hear it.
Getting permission from
I
a
did
single
not-
justice of this court.
I did not ask for leave to do that, if that's the question. Now, under the Quinn case, that's not required, but as the Quinn case suggests, I did provide the panel with information about exactly what I was doing while it was
I'm
pending.
just trying to figure out the judicial resources that have been expended and the lawyers' fees in this case it just seems like there would have been a clearer path to get here, and I just wanted to figure out if you had contemplated that. I agree with you that you're not required to, but I guess just in the future, it seems like maybe we could have had a consolidated appeal if things had gone a little bit differently, but let's move past that.
I was hopeful that it would be, Your Honor, but that motion didn't get any action. My motion to stay didn't get any action.
So is it your view, I know you've asked us in the alternative to decide the motion, which I don't think we have the ability to do, but you want us, as I understand it, to send it back to have a hearing on your motion for relief from judgment. Is that what you're asking?
That is what I'm asking, and the reason is because it's quite clear from the decision that there was no evidentiary record, and I actually think my brother points this out in his brief as well, that the plaintiff didn't have a chance to be heard. This was all a proffer, and that's how it's characterized by my brother as well. The Quinn issue, this threshold issue, was front and center in the motion papers, and I even appended Quinn. It didn't occur to me for one moment that the court would make this error. I thought that it was clearly going to have a hearing on the merits because in the regular course, this judge in particular, and in Framingham, in my experience, that's what they do. So that's what I'm looking for, ultimately. And effectively here, what happened is that there was a legal error that effectively precluded a full evidentiary record from being made and a merits determination from being made. And in those circumstances, as a matter of course, appellate courts simply correct the error, vacate the erroneous decision, and then remand the case back to the trial court for a hearing on its merits. I would submit that under the motion to vacate under 60B, that is in fact the defendant's right here. I would submit that.
Does it make a difference that in Quinn, it was the plaintiff who was seeking to vacate, and here it's the defendant?
No, Your Honor, because in Quinn, I mean, that's correct, and I understand that my brother argues that in his brief, but by the plain text of Quinn, it said, quote unquote, either party, and that's very, very important. I would submit that, especially in published opinions like Quinn, this court means what it says and says what it means. Either party can file a motion to modify, terminate, vacate, and that's in fact what happened in Quinn. Of course, Quinn could have said, well, this is only for plaintiffs, this is only for 209A plaintiffs, but it didn't. So the defendant, in acting as the defendant did, relied on that plain language of Quinn that expressly, and I would submit unambiguously, promulgates this exemption to the general rule that leave of court is required in the 209A context. Additionally, I understand that my brother argues, well, Quinn only does not apply to motions for retroactive relief, and this was a motion for retroactive relief, therefore Quinn doesn't apply, and I would submit that that's incorrect for at least two different reasons. One is, once again, that Quinn could have limited it to just the alleged victims or plaintiffs to 209A. It could have limited to certain types of motions, but it didn't. Either party has a statutory right to this type of relief, and the defendant is, of course, one of those parties. And as such, a pending appeal, I'm quoting, a pending appeal of a Chapter 209A order does not deprive the trial court of, close quotes, jurisdiction to act upon it. I also think it's notable, although I'd submit it doesn't matter, that in Quinn, it's quite clear for a couple of reasons, and I address this in my reply brief, that the motion to vacate did have retroactive effect. The trial court directed law enforcement agencies to destroy all records of it. Now, prosecutions, and there was a prosecution here, remains viable when terminations or vacators only have prospective effect, when a 209A ceases to go forward. And the reason, as this court has said multiple times, including in Smith versus Jones, is that there's the defendant to the 209A retains a vested interest in demonstrating that it wasn't correctly issued to begin with. But in Quinn, the court said that a prosecution could not still potentially arise, and of course the reason is because it had retroactive effect. Otherwise, a prosecution could continue from the time, if the alleged events occurred during the time that the 209A was active, and this is why in Quinn the DA's office had to file a null pros. Additionally, as I mentioned, 209A orders are not mooted when the appeals cease to be prospectively active, but in Quinn the court declined to address the merits of the appeal, finding that—
Let's say we agree with you that Judge Kunis had jurisdiction and he should have considered your 60B motion.
Yes.
As I understand it, your 60B motion was based on the fact that there were some statements in, I think it was the pediatrician records, that were tended to impeach the plaintiff's previous claims. Could Judge Kunis, if we remanded it to him, decide this on the papers?
Had Judge Kunis decided this on the papers, and looked at the merits and said, this doesn't move the needle for me, or something to that effect, then candidly, in that hypothetical, I might not have tried to appeal it to this court because of the substantial discretion. So
I'm just asking you a future question.
Right.
If we were to remand it in the future, could Judge Kunis decide this on the papers?
hypothetically, yes, because as a strictly technical matter, and I cite this case law in the brief, movements under 60B don't have a automatic legal right to a hearing. So when someone lacks a legal right to a hearing, the answer is yes. But
And it's all documentary evidence that's the newly discovered evidence.
so the evidence, yes, but the evidence in the proffer that's appended to the affidavit is only the tip of the iceberg. And this actually goes to an interesting issue where I submitted on pages 21 to 23 of the reply brief what I would characterize as effectively an offer of proof. And as my brother pointed out, it's not in the record, and to which I respond, that's the whole point. The whole point is that the evidentiary record does not contain the full evidentiary record. There is no real evidentiary record. So I submit that to substantiate my assertion that a record with the evidence, with more evidence, is necessary here, and I do that to counter the plaintiff's request that this court decided in the plaintiff's favor at this juncture, which I
You have a record appendix that's 1,356 pages long.
That's right.
That's the longest one I think we've had today. So I'm a little skeptical of saying that there's no record.
The goal here, transparently, was to procure a hearing. It is, to Your Honor's point, it was conceivable, it would have been conceivable for Judge Kunis to say, even if I were to look at the merits, it doesn't matter, I'm not moving the needle. But the goal here was to just give the court enough paper so that it would say, okay, this is pretty egregious. We have direct and deliberately facilitated redactions against court orders of exactly statements, recorded statements by third parties that would have been detrimental to the plaintiff's case. That was the goal here, and I'm wary and aware of the district court's high caseload and the fact that things move very quickly. And so, granted, it was a strategic decision to only include that for the purpose of getting the hearing. And in my experience in Framingham, particularly with Judge Kunis, hearings happen regularly. And I would submit that Judge Kunis is not even attempting to distinguish Quinn in the very short handwritten decision is evidence that Judge Kunis might not have read the papers all the way through. And that was, and sort of foreseeing that possibility, that was part of the reason that I didn't include all of these voluminous credit cards.
As a practical matter, the appeal has been decided, the pending appeal, correct?
The direct appeal has been decided, that's correct.
And the FAR has been denied, is that correct?
Correct.
Okay, so as a practical matter, this can be filed and argued whether we remand it or whether you simply file again. There's
no, and that's
tell me
important.
why.
And the reason that the answer is no, because of course I considered that, is because under 60B, under the new evidence prong, it might not be the same for the misconduct prong, but under the, and I would the basis was new evidence and misconduct, and the facts are sort of interwoven, you only have 1 year. So that's the reason that I had to do this at the exact point that I did. And, the reason that this has shaken out as it did, because I can't refile it.
It can't be filed as a motion to vacate or as a motion?
Not under the plain text.
Some other form of motion?
Not under the plain text of 60B, which is the rule that the motion flowed through.
So go ahead.
Not under 60B, but people file every day motions to modify and vacate 209As.
Right, on the basis of new evidence specifically, I had 1 year. And I would submit, I believe that that's the strongest basis, with misconduct being a lesser basis. But I had 1 year, and there are these new documents. And then, as I mentioned earlier, there are voluminous credit card statements demonstrating that the plaintiff was going dozens and dozens of miles many, many times, maybe 100 times, to the exact neighborhood of the defendant. And all of this was hidden by various mechanisms in sort of an elaborate plot and it was hidden until after the 2023 extension order. So the new evidence...
Does that corroborate her fear? The fact that she's trying to, let's say she's trying to get medical personnel to over-redact the records, and she's trying to prevent the defendant from knowing that she's going somewhere near where he might be. Doesn't that just corroborate that she was in fear of him?
No, Your Honor. If someone lives in, I believe, Belmont and then Amesbury, and they're traveling all the way to Lincoln, and they're doing it so many times every single week to the exact places that they know that the defendant goes to, and then they try to keep that evidence against probate court order secret until after the 2023 extension, that's obviously evidence that you're not in fear. There's tons of coffee shops and restaurants and stuff in between. But in any event, I would submit that this court should remand it to the trial court to decide these things. Ultimately, I would submit that, and this is what I would argue to the trial court, what we have here, the documents, are decent length and decent weight straws that would hypothetically break the proverbial very weak camel's back. Even per the plaintiff's counsel, during the hearing, the plaintiff's counsel said, and I'm quoting, "If the defendant had not been pushing the boundaries of permissible communication, there may be some grounds not to continue the 209A today." That's on Record Appendix 299. Even the plaintiff's counsel recognized how weak the evidence was, and this is why in Record Appendix 141 to 142, the Judge Cunit is saying, when did the defendant even say anything inappropriate? When? Tell me when that happened. When did he say something that wasn't about? And that was at the close of the plaintiff's evidence, to which the response is at a tail end of a message about, like your glasses.
Please don't use any names.
Sorry, yes. That I like your glasses. And when he said, I just want to make you happy, after the plaintiff had sent him a message saying that they assumed that we could talk during the pickups. I mean, this is not a strong case, and that's why I took a shot at this anyway. But ultimately, I think remand is appropriate here due to the clear error of law pursuant to this court's published holding in Quinn.
Thank you.
Thank you. Thank you.
Attorney Madison? Good afternoon.
Good afternoon, and may it please the court. Nick Madison for the plaintiff, MB. This is the plaintiff's third appeal from the same restraining order docket. And here today, there's one issue, which is the jurisdictional issue. And then there's a separate issue that I'd like to highlight for the court, which is the underlying merits of the motion, which provides an alternative basis.
Before you continue, do you agree with your brother's view that he is precluded from filing a motion to vacate, a motion to modify, or other form of motion on the basis of this newly discovered evidence, because the sole vehicle is through Rule 60B?
I believe that, so pursuant to Mitchell, we analogize to Rule 60B, both under the rules of domestic relations and the rules of civil procedure, which are fundamentally the same. Under that rule, again, if the analogy holds, which is how this court has treated it, you do have a 1 year time frame from the entry of judgment to file your motion. So I would agree with that, that he would be precluded from filing a new motion at this point because he filed the last motion perhaps a day or two before, I believe it was February 6th, which was 2 days before the anniversary of the
Are
hearing.
all motions to modify abuse prevention orders and all motions to vacate abuse prevention orders, do they all fall under 60B or just those for newly discovered evidence in this context?
So that's an interesting question, Judge, and it actually bears on what relief the defendant was asking for in this motion. So in Mitchell, which is the seminal case on both prospective and retroactive relief, the court analogized to, the court distinguished between the legal bases for retroactive relief on one hand and prospective relief on the other. For retroactive relief, it said that, the court said that the legal basis for this comes from 60B, that the order shouldn't have entered, that there was some reason why the order shouldn't have entered in the first place. As to prospective relief, the court identified two bases of law. One being the statutory right within 209A for either party to seek modification of the order, and for a separate section of 60B, which analogized to that allow for parties to move to modify a order that has prospective effect, I believe 60B5, if memory serves, where it is no longer equitable for the motion, for the order to have prospective effect. So yes and no is the answer. The court identified two bases of law, one of which was within 60B, although a separate section, and another which was coming from the right to modify within 209A. And I would just distinguish that point from what defendant's counsel said is 209A does not by its text provide a right to retroactively vacate an order. It says either party has a right a right to move for modification at any time. And so
what section of 209A itself says that?
209A, I believe section 3, but I might be a little out over my skis on that one, as to the particular section.
So again, if the statute says that you have the right to modify at any time, a modification can be based on newly discovered evidence, and the statute can't be trumped by the rules. So that goes back to my question. What bars him from filing that motion again right now?
So the difference, the distinction is between prospective and retroactive relief. The defendant could move for prospective relief at any time, although it would become mooted once the order expires of its own, by its own terms. For retroactive relief, and this again gets to Mitchell, because Mitchell identified as the legal basis for retroactive relief the sections of 60B that are time limited, that retroactive relief would be time limited, prospective relief would not, as long as the order is still in force. Otherwise, a request for prospective relief would be mooted.
Okay, I just have a little difficulty with that. I understand what the cases say and how they interpret retroactive versus prospective relief. But again, if you have a statute that says you can file a motion for modification at any time, that trumps a rule that puts a time limit on it. You're moving through a different vehicle.
Yes. The distinction I would point to, Your Honor, is that modification would imply prospective moving forward, changing the terms of the order, or even, you could argue, terminating it going forward, versus retroactively vacating the order. So I would argue that the rule is not in conflict with the terms of 209A.
Section 3 is, I think it's broader than that, right? It says the court may modify its order at any subsequent time upon motion by either party. It doesn't define modify as prospective, as retroactive. It doesn't say it has to be a motion to vacate. It just says to modify, which to me means to change it.
Your Honor, that distinction I would refer to Mitchell, where it suggests that modification connotes a prospective change in the order. Retroactively.
I'm not asking you to concede the case, certainly, but is it, you agree with brother counsel then that the relief that he was looking for in this motion could only be filed in a 60B motion?
That is complicated by the, I can't answer that question directly, and I'll tell you why. If you read his motion that he filed in the lower court, the defendant is now saying that was requesting prospective relief. I would invite the court to read the motion because I don't think any judge would be reasonably on notice that it was requesting prospective as opposed to retroactive.
Well, he's asking the judge to vacate the order ultimately based on, I understand what you're saying. By the same token, we can envision a scenario. I could come up with a million hypotheticals, or let's say we have such extraordinary evidence. I'm not saying this is or is not this case, but we could envision a scenario where there's such extraordinarily powerful, newly discovered evidence that just shows the trial judge, the district court judge, you got this wrong, and everyone would have to agree with it. But if we agree with you, there's no jurisdiction, and it's too bad, so sad. Yep, we all know we got it wrong. What remedy is there then?
So,
he's still seeking retroactive relief.
So if he's...
By definition, there's no jurisdiction still, and he's out of luck, or his client's out of luck?
So if let's imagine there was a videotaped recantation of the key bases for the order, and that the defendant wanted to present that of the person saying, I lied, not that this is this case, for the sake of the hypothetical.
We're speaking hypothetically, yeah.
In that case, it wouldn't be the defendant would have a year to present that evidence, but there's no reason to say that that couldn't be told by a, say, discovery rule of when he learned of that evidence. And he certainly could argue below that I didn't learn of this until a year plus 1 day.
Can he do that here?
He can't, and this is an important point, because I think the defendant was suggesting that he had to rush to the courthouse and file this motion. In the defendant's affidavit, which was included with the motion to vacate in this case, he received this information in October of 2023. The 1-year deadline was in February of 2024. He had 5 months to review this information, file it, and present it to the court. And to claim that he didn't have the ability to do so, particularly when he's not pointing to any other evidence aside from these documents that he received in October of 2023, is a wrong impression by the affidavit that the defendant supplied. So, turning to the merits of the motion, I would suggest to the court that reviewing the merits, applying the well-established law in Mitchell, assuming the truth of all of the allegations the defendant is making in the motion, this court can determine that it does not meet the standard for relief and affirm the judge's order on that alternative basis. And the reason for that, I think it's important to put the newly discovered evidence in context of the motion, of the evidence that justified the order. The last panel of this court, when in deciding that case, went into some detail of the basis for the order. And I won't repeat it all here, but I will just focus the court on that it involved substantial sexual and physical abuse on behalf of the defendant towards my client during the marriage, and more recently, in the days and weeks preceding the last extension hearing, the defendant had used surreptitious access to my client's Google Calendar to give the plaintiff the impression that he was tracking her and to uncover the address of her recently purchased house that she had used the address confidentiality program for domestic violence survivors to purchase. He used entries in her Google Calendar to uncover the address of that house. The court found, notwithstanding the defendant's argument that this was a very weak case, I believe the term the last panel used was ample evidence to support the issuance of the extension underlying this order.
Can I just ask, just on a yes or no, the parties are divorced and custody is resolved in that divorce, is that right?
The parties settled the divorce proceeding. This is not in the record. I am aware that and a judgment entered of divorce. There are pending probate, pending matters in probate subsequent to that.
Leave it there if it's outside the record. Thank you.
And so this newly discovered evidence, the main piece that the defendant puts emphasis on is the statement in January of 2021 that the plaintiff reports feeling safe. Whether you look at that through the lens of being cumulative, because there was evidence in the record at the hearing that merely 2 weeks before, the plaintiff told a social worker from DCF that she felt safe, whether it's that it was just merely impeaching of her testimony at the hearing that she remained in fear of the defendant, or whether you can consider the substance of it, that the fact that the plaintiff was reporting feeling safe, just looking at the context within that record, within that sentence and the sentence before, she reported feeling safe while protected by a restraining order and while she had moved out of the house, and we know from the restraining order that her address was impounded at all times. So what she's saying there is, I feel safe when I have a restraining order and the defendant doesn't know where to find me. That is not the same as saying that she's not in fear of the defendant or that she doesn't require an order of the defendant. It's saying that with the protections she has at that time.
What things like this mean really is classic duel of credibility and fact-finding that we are really not suited to determine. I appreciate your arguments and I understand them and I may or may not agree with them.
Certainly, Judge.
But that's exactly why this typically would need to be resolved by a finder of fact, hearing testimony, making credibility determinations, and determining what that means in context if presented as such.
Certainly, Judge. And judges have a large amount of discretion in these sorts of post-judgment motions. But I would say that when you look at there being very similar evidence in the record at the hearing, the argument that Judge Kunis would have, this would have changed the outcome when he had very similar evidence that she was safe, evidence.
But Judge Kunis could have said, I do not have jurisdiction. In any event, if I did have jurisdiction, I would hold that these documentary references merely impeach the credibility of the plaintiff, or maybe they don't, and they don't change my decision. That'd be a different case, though.
It certainly would, and I very much wish that Judge Kunis had made alternative findings because it would have saved us all a lot of time and expense. But I would suggest that where this issue has been fully briefed by the parties, there's a judicial efficiency argument for, if it can be decided on that basis, deciding on that basis where it would avoid yet another trip to this court if and when Judge Kunis denies it on the merits of relitigating the same issues again on appeal. So if there's no more questions, the plaintiff is asking the court to affirm Judge Kunis's decision denying the defendant's motion to vacate.
Thank you very much. Counsel, very well argued. The matter is under advisement. That concludes our sitting for today. I would like to thank the court staff, in particular our court officers, the clerk's office, our law clerks, and our wonderful timekeeper today. And we will stand in recess. Thank you.